Good morning, everyone. We are now on the record and video streaming. I call this evidentiary hearing to order for docket number 23 CONS 3176 CPEN in the matter of an order to show cause issued to Great Plains Petroleum, Inc. for a plugging order at the Stumps number 4 well in Barton County, Kansas. I'm Susan Duffy. I'm serving as chair of the commission and will serve as presiding officer for this hearing. I'm joined by my fellow commissioners, Andrew French and Dwight Keene. I would like to begin with entries of appearance, and I'll start with commission staff. Mr. Kimbrell.
Thank you. Tristan Kimbrell on behalf of commission staff and the public generally.
Thank you. And the operator, Mr. Steinkamp. Good morning.
Good morning. Chris Steinkamp with the Pugill and Rathman and McIntyre. I represent Great Plains Petroleum, Inc. And I also have with me Rod Ferries, who is president of Great Plains.
Very good. Thank you. Does staff have a recommendation regarding notice of this hearing?
Yes, notice of this hearing was contained in the presiding officer order setting.
Mr. Steinkamp, can you mute your microphone, please?
This is John Myers. Actually, I believe it's Rich Williams' camera.
Okay, Rich Williams. Okay. All right, here we go. Mr. Kimbrell, if you will begin again.
Notice of this hearing was contained in the presiding officer order setting evidentiary hearing filed on August 4th, 2023. The order was properly served on all parties. Staff further notes that all parties are in attendance today. Based on these facts, staff recommends the commission find that notice is proper and that the commission has jurisdiction to hear this matter at this place and time.
Very good. Are there any objections to notice? Hearing no objections. And based on staff's recommendation, I find that this notice is proper and that commission has jurisdiction over this proceeding at this time and place. We're going to go to preliminary matters now. Let's first begin with the fact we are conducting this hearing over Zoom. Sometimes technical issues do arise. If any party encounters a technical issue, just ask to go off the record. We'll resolve the issue and go back on the record. Second, witnesses are asked to keep their microphones off or muted when they're not talking. And if everyone would mute their cell phones, phones in the office, and other devices, that would be helpful. So that parties are aware, if the commission needs to consult among ourselves, we will go off the record and enter what's called a breakout room, a Zoom breakout room, and discuss what we need to. Then we'll return to the breakout room and go back on the record. Since we are doing this by Zoom, be very careful to identify exactly what you're referring to when discussing pre-filed testimony and filings. And we have copies of everything, so we should be able to follow along. Plus, John does a great job of pulling things up on the screen. I also anticipate that we'll break maybe after 90 minutes or so, maybe a little bit earlier. So let's go through our procedure during the hearing. In regard to procedure for the hearing, parties are allowed to make opening statements. After opening statements, we will have examination of witnesses. After direct examination of each witness, there's an opportunity for cross-examination, commission questions, and redirect. Any further examination will be at the discretion of the commission. Following witness examination, parties typically will make closing statements and arrange for the filing of post-hearing briefs if necessary. And then we will conclude the hearing. So let us move to opening statements.
Commissioner Duffy, sorry
Yes.
to interrupt. Myers here. It might be useful to ask the parties if they have any preliminary matters to bring up as well before we get to the
absolutely. So let me turn to the parties. Do you have preliminary matters that need to be addressed? And I'm looking at Mr. Kimbrell.
Yeah, Chair Duffy, I believe Richard Williams has indicated he doesn't have audio. If we could go off the record briefly to get that fixed.
Okay, all right. Why don't we, John, why don't we do that right now? There's
Yep.
an audio issue.
We'll see if we can get that sorted. Yep.
Okay, so we're gonna stand at ease till that is taken care of.
All right. Tristan, are you calling them up to see? Okay, sounds good. Thank you. All right. We've not had district staff have an issue with audio before. That's a new one.
Yeah, I agree. He sound checked okay.
Yeah, yeah. You know, I saw the when it was, in fact, it was from district that the noise came that was interrupting Chair Duffy a little bit ago. And then I saw it went on mute.
I wonder if they muted their speakers when he was trying to mute his microphone.
Yeah. Looks like.
Yeah, we might want to check that out because I agree if that may be the issue.
Looks like they have dropped from the call as the Zoom meeting as well. So they might be trying to rejoin. Yeah, we just readmitted him. Okay, he's readmitted. He's showing up as on mute. I'm going to press the button that asks to unmute, see what happens. I think they can hear us as well. Just I might be wrong, but
Rich, can you hear us now?
yeah, Rich, give a thumbs up or something if you can hear us. We can't hear you. Oh, there, you did something. Say something. There we go. Yes.
Can you hear us,
Yeah.
Rich?
Yep.
Oh, okay.
That took care of the problem. Whatever you just did took care of the problem.
Yeah, we had to reboot it.
Okay,
Okay.
very good.
Chair
So,
Duffy, I think preliminary matters, we're okay to go back
Sure.
on the record and deal with those.
very good. We are back on the record. We are discussing preliminary matters and Mr. Kimbrell, do you have any matters?
Staff has no preliminary matters.
Okay, very good. Okay, Mr. Steinkamp, do you have a preliminary matter?
Yes, Mr. Commissioner, we filed a motion for a continuance. We had been talking with the staff about potentially continuing this hearing. And there is a motion, I think, before the commission now to continue this hearing on the basis that we are currently actively litigating a partition case on this lease property. Great Plains owns a mineral interest in the property, and it is trying to clear up some other interests owned by a number of people who are frankly very contentious and have been very difficult. And we believe that it would be most efficient to continue this until the partition matter is over with. Frankly, if certain parties end up buying all of the minerals as part of the partition, then these wells are all going to be plugged no matter what the commission says, because they're parties opposed to having oil and gas production. If, on the other hand, Great Plains buys the minerals, then it will be both 100% mineral owner and the operator of the lease, and I think it will be in a position to move forward quickly with getting this lease back into shape and back into production.
Mr. Steinkamp, we've this has been out here for a long time. This is not a new issue come lately before the commission. And we've got this, everybody is here, and I'm going to deny your motion. There's been ample time for activity to occur. Your motion is denied. So I'm assuming there are no other preliminary matters.
Not for me.
Okay, very good. We're going to move on to opening statements, and I'm going to begin with Mr. Kimbrell.
Thank you. Commissioners, the well at issue in this docket, the Stumps number 4 well, has been out of compliance with commission regulations for 5 years. 5 years that it's sat there and been a potential threat to the environment and a potential threat to correlative rights. And the reason it's been out of compliance for so long is because staff has tried on multiple occasions to work with Great Plains to get this well into compliance. Unfortunately, staff's attempts have been taken by Great Plains as an opportunity to stall and delay and not do the necessary work to bring this well into compliance. And frankly, this hearing is just one more attempt by the operator to stall and delay. As the evidence today will show, the Stumps number 4 well has not produced oil since at least 2015. Operators not injected fluid into the well since at least 2017. In 2019, the commission issued a penalty order because the Stumps number 4 well was not in compliance with the injection permit issued for the well. Staff tried to work with operator, agreed on a plan with operator to bring the well into compliance, but operator didn't follow through. And so finally, staff revoked the injection permit for the well in 2022. As has already been mentioned, operator is probably going to argue today that there's a petition to partition, that the commission should wait and not take any action until that's been decided. But honestly, that's again just another attempt to stall and delay. Staff believes that the Stumps number 4 well should be plugged because it's been out of compliance with commission regulations for so long, and because it may pose a threat to fresh water and correlative rights. If the commission orders operator to plug the well, then the outcome of the petition to partition doesn't matter. If, however, the commission is inclined not to order Great Plains to plug the well, then staff believes operators should at a minimum be required to take certain steps to make sure that the well no longer poses a threat to the environment or correlative rights. And staff believes that Great Plains should be required to extend the surface casing on the well, to seal the perforations in the producing interval of the well, perform a successful MIT above a packer placed directly above the injection zone, fill the tubing casing annulus with corrosion inhibiting fluid, and then file a new application for injection authority for this well. If the commission decides to order that these steps be taken after the petition to partition has been decided, that's fine, but at least there wouldn't be any more stalling and delaying by operator, and the Stumps number 4 well would finally be brought into compliance with commission regulations. Thank you.
Thank you, Mr. Kimbrell. We'll move to Mr. Steinkamp, please, for the operator.
Thank you. I appreciate you all giving me a minute to address you about this matter. I would just observe that I think that I conducted, as I understood it at the time, the first Zoom hearing before the commission a few years ago, and things are a lot more sophisticated now at the commission. They are probably not more sophisticated for me. So if I manage to screw this up, I hope that you'll give me a little grace to get things fixed. I have my associate here who is more tech savvy than I am to try to help me. So I want to say that at the outset. Turning to the matter at hand, I mean, this is a well that was drilled in 1964 and was completed at that time pursuant to the appropriate regulations of the Kansas Corporation Commission for the protection of groundwater and safe and usable water. It was later dual completed in the Arbuckle, both as a producing zone at the top of the Arbuckle and a disposal zone at the bottom of the well. And in approximately 2015 or 16, it started having some issues. In 2018, there was an agreement with Renee Stuckey of the commission to reconfigure the well in a way that would allow a mechanical integrity test be conducted, because dual completed wells cannot be MIT'd in the same manner that a single wellbore completion is. And so the well was recompleted pursuant to that agreement with Mr. Stuckey, and it passed its mechanical integrity test in 2018. After that was done, it has continued to demonstrate that it holds pressure in that configuration as late as February of 2022. And we would certainly expect if we went out there this afternoon and tested it, it would continue to hold pressure today in that configuration. Mr. Kimbrell said that this well's been out of compliance since for 5 years, which I actually, the well was properly TA'd by staff in both 2018, 2019, and 2020, and was subject to proper TA through December of 2021. So in fact, it's been about a year and 8 months or so since the TA application to renew was denied by staff, at which point the staff argued that it was then out of compliance. And so it's not quite as egregious as maybe has been represented here. The other thing that is very important is the title to this lease has become very convoluted. There were a number of interests in the property granted by prior owners, including term mineral interests, that have caused this this property to become frankly fraught with incredible amounts of difficulty. And if you review the title affidavit that is attached to Mr. Ferry's pre-filed testimony, I think you can get a flavor for how complicated the title is. The current surface owner believes if he stands in the way long enough, the term mineral interests that are out there will expire and he will suddenly become the title owner of all of the minerals, which frankly is not correct. But nonetheless, that's been his position. As a result of all of those things, Great Plains obtained a new lease from one of the owners in 2022 to make sure that its title to this lease was valid. That lease is provided to the commission and is attached to Mr. Ferry's testimony. Attempts were made to lease from a number of other owners, certainly not all of them, but as you review the title affidavit, there is a very long list, including some charities, including the state of Kansas, which claims that it is precluded from owning title of this lease, but nonetheless, it was granted title in a probate matter. So the partition is trying to sort all of those things out. And frankly, that's a lot more complicated than it sounds like. And so, again, I would refer you to the title affidavit to get a sense of the complications involved in that partition. In July, Great Plains bought a mineral interest and is now a mineral interest owner in this property. That is an important fact, and it has a direct interest to make sure that the minerals are produced and sold on this property. They are diligently prosecuting this partition action. Answers are expected to be due by September 11th or so. There may be continuances sought, but very soon the publication deadline for the unknown parties will run on September 11th, and the partition action will proceed with the valuing of minerals and likely a sale at the courthouse steps. So we believe, and I'm not aware of any evidence to the contrary, that the reconfiguration of the well directed by Renee Stuckey continues to make this well protective of fresh water and to protect against waste. And we believe that the commission by ordering that this well be plugged will convert the possible, I think the word used by staff is potential waste and potential threat to water into an actual waste, because this well will be plugged and abandoned and it will no longer be allowed to produce oil and gas for the owners thereof. So we would ask that if the commission is inclined to make some sort of a ruling requiring plugging, that it do so in a way conditional on obtaining the end of the partition action and giving Great Plains the opportunity to go in and get the title resolved and get this well back into compliance prior to having to plug it. Thank you.
Thank you. Okay, we're ready to proceed to the examination of witnesses. And Mr. Kimbrell, you may call your first witness.
Thank you. Staff calls Richard Williams.
Okay,
Very good. Mr. Williams, if you'll raise your right hand, please. Do you swear or affirm that the testimony you shall give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Kimbrell.
Thank you.
proceed.
Sorry. Thank you. Mr. Williams, could you please state your full name for the record?
Richard K. Williams,
By whom and in what capacity are you employed?
Kansas Corporation Commission. I am the TA coordinator and also compliance officer for District 4 Hayes.
And what is your work address?
23013 East 13th Street, Hayes, Kansas.
Are you the same Richard Williams who caused to be filed in this docket direct testimony consisting of 6 pages and 5 exhibits, as well as rebuttal testimony consisting of 3 pages?
Yes,
Was this testimony created by you or at your direction?
yes,
Now that you are under oath, do you have any corrections to make to your testimony? If I asked you today the same questions contained in your testimony, would your answers be the same?
yes, it would.
Do you swear the answers contained in your pre-filed direct and rebuttal testimonies were and are true to the best of your knowledge?
Yes,
Chair Duffy, at this time, I move for the admission of Richard Williams' pre-filed direct and rebuttal testimonies to the formal record.
Very good. Any objection? Hearing none, it's so admitted. Thank you.
And I attended the witness for cross-examination.
Very good. Mr. Steinkamp, do you have questions of this witness?
I do. Thank you. Mr. Williams, would you agree with me that this well was reconfigured in 2018 pursuant to an agreement with Renee Stuckey at KCC?
it was, the agreement was within the 6 months that Mr. Fars would showcase an integrity at that time and then reapply the application. And they did that. We approved it at that point, but they failed to refile for that application, or they filed the application, but they failed to follow up and supply the information needed that was requested by Jerry Noble.
Well, if you could answer my question, and my question was the well reconfigured in 2018?
At that point, it was, yes.
Okay, thank you. And after it was reconfigured, the well held pressure 300 pounds, correct?
Correct.
And it was passed, it passed a mechanical integrity test based on that reconfiguration and compliance with the revised configuration, correct?
It passed according to what we had recommended, yes.
Okay. Was the well retested in 2019?
Yes, it was, because they filed a TA and I denied it, requesting a new MIT on it.
Okay. And did the well continue to hold pressure in 2019?
Yes, it did.
Okay. And has it been tested since then?
They did one in February 9th of 22. And as far as the TA application, it was approved by me because of the unknown of the actual, if it's a disposal or oil well or what. But anyhow, it did pass then, but it did not meet the criteria that was set forth by Mr. Renee Stuckey. and our UIC department denied it because it was not, did not meet the parameters of the permit that was on hand.
Okay, so let me understand what you're saying there. The well held pressure, indicating that it was not leaking or creating a threat to fresh water, correct?
At that point, yes.
Okay, so the denials of passing the MIT was based on paperwork in the KCC's office, correct?
No, it was based on the permit that was out at that time. The permit, the docket that was holding the permit, was a dual completion deal. The only reason we did the MIT with this down below was to showcase, to prove to us that it did have some integrity, and also give him time to get the application filed, which he failed to do. And the MIT for a TA is good for 3 years. That's why I requested another one to be done, so we could continue on with getting this well bore to make sure we had integrity, yes, at that point. But as far as the UIC department, it did not meet the criteria for their docket that was on hand at that time, being a dual completed.
Right, so I guess if you could answer my question, which is the issue was not that the well was leaking, the issue was that it didn't meet the requirements of a permit at the KCC, correct?
Correct, but also as a compliance officer, I have to look at the docket, the way it's written up as one on a dual completed well. When one side ceases, it is to be immediately shut in and either plugged, repaired, or approved for TA status at that point.
I understand. Did you approve TA status on this well in 2018, correct?
We did the MIT on 9/14/18. We approved it, yes.
Okay, and you also approved TA status in 2019, is that correct?
19. Yes, I did.
And you further approved TA status in 2020, is that correct?
Correct, because we were trying to work with Mr. Fars to get the application, Jerry Noble's request and everything. And MIT was good for 3 years, like I said before. And then I denied it in 21, and he did another integrity in 22. And still showing integrity at that point, but not to the docket, but also as an oil well or whatever he decides to do with it. That's where it was set at.
Okay. So is there any evidence in your files or that you're aware of that shows that this well is causing any actual pollution to fresh and usable water?
I don't have any evidence that it's, the correlative rights issue comes in effect where we have the upper Arbuckle, which is producible and producing in offset production, versus this one and with a deep, open hole disposal. So as far as having any proof of it affecting them right now, I do not, but it is their correlative rights issue.
But I guess my question was, there's no evidence that any of those things are occurring, correct?
As far as the correlative rights or what, an MIT?
Let's talk about them one at a time. Is there any evidence that you have that shows that fresh water is being polluted by this well?
Not at this time, but we don't know about the annular flow and everything else up through the Dakota section, so I don't know.
But the answer was no, you don't have any evidence that there is any pollution occurring, correct?
I don't know.
Okay. And do you have any evidence that this well is impacting correlative rights of any other offsetting leases?
I do not.
Thank you. Have you examined the title to this property?
No, I have not.
Okay. Have you had any experience with partition actions?
No.
I'm sorry, I didn't understand. I still couldn't hear you. I apologize.
I think are in. No, I have not had any participate in a partition suit or anything.
Okay. So, I was just gonna ask you, you make some comment that, in your rebuttal testimony that, the operators filing the partition action, I guess at the time they did, you thought was based on, this, this docket as opposed to the operator trying to clear title. Am I right about your testimony?
What's your question again? Repeat that.
Well, I'm gonna read it to you. It's line 12 of page 2 of your rebuttal testimony. And it says operator filed the petition on July 12, 2023, the same day the operator filed the testimony in this docket. It appears that operator only took action to quiet title because the commission opened this docket. Is that right?
Correct.
Okay. But I think you mentioned that you don't have any experience with filing partition actions, correct?
No, I'm not an attorney and I don't get into that. No.
Okay. And you don't know what might be involved in preparing and getting something like that done either, correct?
No, I'm sure it's a lot of paperwork, but no, I have not. And it's been 5 years and that's, so.
Okay. Well, is a well that's properly TA'd, is that considered to be in compliance with commission regulations?
To a certain point, yes, as where this met the criteria as an oil well, but it still had a docket at that time before it was denied here in 22 because of the show cause hearing and when they canceled the permit.
Right, but you're the one that approved the TA through December of 2021, correct?
Correct.
So was it in compliance with commission regulations through December of 2021?
To a certain point, as far as the integrity on it being a base of an oil well, yes. With the docket as an SWD, no. But that wasn't my department to do that. That was up to the UIC department to deny the MITs. And if you look at the copy of the MITs, they stated right on there, does not comply with the parameters of the docket.
I understand that, but I think you testified that a properly TA'd well is in compliance with commission regulations, correct?
As an oil well, yes.
And this well was properly TA'd through December of 2021, correct?
To the point, yes, we were trying to work with Mr. Fars, but yeah, he did show integrity again. So that's where we're at.
Okay. Thank you. Are you aware that Great Plains owns a mineral interest in this property?
Yeah, he sent us a copy with the renewal in 2021 or 22 when he bought that.
Okay. You testified in your pre-filed testimony that you didn't believe, and I think this is on your direct testimony, that you had talked to one of the landowners, and that landowner believed that Mr. Ferries or Great Plains did not have a valid oil and gas lease. Which landowner did you talk to?
That's been years ago. He was actually trying to file, he was thinking about filing a complaint on it. Want to know what he needed to do as far as getting his wells addressed. I really don't know what the landowner's name was. He's the new tenant out there, Mr. Fars, you know who it is. He was the one that was raising the, the issues with everything.
So he was a tenant on the property?
The new owner of the property, you know,
Okay. Would it potentially be Mr. Cryer?
I believe that's correct. Pete Fryer, I think it was that right?
Probably. He's one of, I'm not sure how many, probably 30 some owners. I could direct you to page 3 of the title memorandum attached to Mr. Perry's direct testimony. Do you have that?
Yeah, give me a minute. We got a lot of orders here. What page did you say?
It's on page 3 of the title memorandum.
Okay, oh, that's the one they just sent here lately.
It was filed with Mr. Perry's testimony.
Okay, page.
It's the one with the big box that has all of
I
the.
got it.
If you got
Peter
that.
Black's career and Lois career, yes.
Yep. Is that the individual that you talked to?
I believe that was correct, yes.
Okay, and that's the basis for your evidence that Great Plains doesn't have a current lease?
And no, a lot of the letters I had received over the years from Mr. Fars, from Great Plains and everything, actually said that his attorneys advised him not to do anything till he had a upstanding lease on it or whatever, or had a valid lease. And there were several times he had stated in many letters that he did not have, he did not know if he had a valid lease.
But that isn't what you were talking about in your testimony, was it?
I'm sorry, we broke up again, what?
I said, but that isn't what you were relying on in your testimony, was it?
As far as,
I mean, I'm looking at the question and answers on page 5 of your direct testimony, lines 12 through 15.
I was taking it off of what Mr. Creer had said, you know, and I mean, that and the letters I had received from Great Plains stating that he did not have a lease. You know, that's basically what I took it off of. Usually when an operator tells me he doesn't have a lease, there's some skepticism that he doesn't have one.
But that, I guess my point is that you were relying on Mr. Cryer's testimony or statements.
Oh, I started reviewing the whole file and going back. It goes back. We got a file pretty thick of 98. Mr. Fars saying he had some seismic shots he would like to do, whatever, drill. You know, but he didn't want to pursue it until he had a valid lease on it.
Okay. And are you aware of the lease to Great Plains from Rita Hammond?
Am I aware of the lease? What?
To Great Plains from Rita Hammond, who is a mineral owner?
No.
I think that's also attached to Mr. Ferry's testimony. We'll find it here in a second. It is Exhibit B on Mr. Ferry's testimony. Do you see that exhibit?
What page is it on in the exhibits? That's
Exhibit B is about 2 pages back from the end of his
Got it.
actual testimony.
okay. Yep, from Rita A. Hammond and Harlan H. Hammond.
Correct. And that covers the premises that is at issue here, correct?
It says it includes 160 acres of the northeast quarter of section 31712. Yes,
Okay, and that's the same property that's at issue in this matter, right?
correct.
Okay. And so, and that's a 3-year lease from April of 2022, correct?
Yes,
Okay. So whether or not Mr. Ferry's had a valid lease or not, prior to that, he certainly has one as of the day of this lease, correct?
no, I do not believe so. I mean, why is he partitioned if he has a valid lease?
Well, because if you go back to the title affidavit again, you will see that Rita Hammond owns only 0.0625% of the minerals in this matter. Mr. Career only owns 1/8 of the minerals in this matter. You see those things? I'm sorry, do you see where I'm talking about there?
Yes, I do.
Okay. Does that make sense to you why we're filing a partition?
Like I said, I'm not a lawyer and haven't dealt with this. No, it does not. When an operator states to me that they are, leery of going on to the lease because they didn't have a valid lease, and then he buys some minerals so he could partake and go on the lease, I guess, by the way I understood. I don't know if that's true or not, but and then you partition it, it kind of pretty sends up a red flag that you don't have a valid lease. You have something in the back of your mind, you don't have a valid lease. So that's where I'm standing with that.
Okay, well, I guess that's a legal issue, so we'll leave you alone on that. So let me ask you this, when you granted the TA on the well in 2018, 2019, and 2020, those are all issues that you evaluate in the process of determining whether a TA should be granted on a well, right?
Correct. He had passed the MIT that we requested per Renee Stuckey with the way setting the packer above both zones and giving him a time frame to get it done, and he did not. So theoretically, I probably should have failed it with our UIC department, but we had several different orders on it at that time in 18. So
Okay. Can a mineral owner produce minerals from their property as far as you know, whether or not they have a lease?
I'm not an attorney. I can't answer that one.
Okay. I don't have any further questions. Thank you.
Thank you, Mr. Steinkamp, and we will turn to commissioners for questions. I'm going to begin with Commissioner Keen. Do you have questions of this witness?
Yes, thank you. Good morning, Mr. Williams.
Sir.
I have several questions for you. I have a lot of questions for the operator. Can you hear me?
Yes.
I have a lot of questions for the operator when we get to that point. How many wells are on this lease under the operator's current well inventory?
There's 2 wells, Stumps number 2, which was a producer, and the Stumps number 4, which is a duly completed well.
And what's the status currently of the Stumps number 2?
It's been inactive since 2015. So it becomes a 10-year well here in 2025.
So it's
We lost.
it has TA status. Is that what you're saying?
They did do an MIT on it to hold the TA status on that one, correct.
And that's good through 25, did you say?
He is actually past due on refiling the Stumps number 2 TA application.
What does that mean? He's refiling. What does that mean?
His TA had expired on it. Get it here. It expired on, oh, I'm sorry. That's 2. The last one he filed, it expired on 4/21 of 23.
Okay, so in April of this year, the TA status of the Stumps number 2 expired. Is that correct?
I don't know what's going on with our audio here, but I'm losing you. It is approved. It was approved to 4/21 of 22, and he has not refiled it.
So it's been over a year that well has been inactive without TA status. Is that correct?
No, I'm sorry. It was filed on 4/21 of 22, approved to 4/21 of 23. So he's basically four months out of compliance on it.
Okay. Has an application for further TA status been filed?
No,
No.
no, it has not.
Now, you are the compliance officer for District 4, are you not, Mr. Williams?
Yes, I am.
Why would the commission not consider taking some kind of action, given the fact that it appears that this well's out of compliance?
Doing both of the programs, I was going to send them a notice of violation letter, but due to the question of the valid lease, I decided to see where this docket was going to go before we pursued it any further. That's on my part there. I mean, if I approve it and he says it has a valid lease, then I'm kind of contradicting what we're doing on the number 4.
Okay. Correct me if I'm wrong, Mr. Williams, but you're not an attorney, are you?
No, I am not.
So really, how could you possibly respond to technical legal questions regarding either petition or lease validity? You really couldn't, could you?
No.
Okay. Actually, it's beyond the purview of your job description as well, isn't it?
Pretty much.
I know there's probably a lot of people out there that'd like to put you in the middle and have you serve as judge, jury, and all the rest, but you're not. You're a compliance officer.
Correct.
Mr. Steinkamp asked you if you had any evidence that indicated that this well was creating a pollution risk. Do you recall that question?
Yes, I do.
Let me ask you the question. Do you have any evidence that this well is not creating a pollution risk?
No, I do not. I mean, when you have offset production within a half-mile radius of this wellbore, it's very possible, but when it's going to happen, nobody knows. I mean.
Okay. A further related question. When you go through the process of analyzing and then ultimately either accepting and granting TA status or denying TA status, let's say you go through that process and you grant TA status. Does that mean that that well is in compliance with all KCC regulations?
It's not.
I'm sorry.
No, it does not. As far as I checked for a current MIT, and we did have a current MIT on it for the casing integrity. But as far as the UIC department's regulation of the fulfilling the refiling the UIC permit for the new application, I didn't look into that.
Okay, so basically, what it says, and correct me if I'm wrong, I want to be very precise. I want to be very exact here. The details are very important. Once you grant TA status, it means that within the confines of the requirements of the regulation and the procedures that execute that regulation, that's been compliance with that. It doesn't mean that that well is in all other respects in compliance with KCC regulations. Is that correct?
Yes.
Let's get into a little bit more of the details here. I don't want to skip rocks over the pond. I want to really kind of have you have us benefit, the commission benefit from your knowledge and your experience, as substantial as that is, Richard. When you were asked questions about from Mr. Steinkamp about the reconfiguration of the well in 2018, what the devil does that reconfiguration mean? What does that mean in essence?
It was a dual completed well. They were disposing into the open hole Arbuckle, the lower Arbuckle. And then he had a Model D packer in the hole, and he had 2 strings of tubing, and he was producing the upper, within 5 foot of the upper Arbuckle from the top. He was producing that as a producer and then disposing down into the open hole through the other string. When he decided to abandon the well, and he said he could not produce it or whatever. I don't know if it was due to the power lines being wiped out, or he had a tubing leak or what. Mr. Renee Stuckey and them, for him to continue on, I believe it was a 6-month grace period they gave him to perform an MIT by pulling that Model D out, the 2 strings of tubing, and run a packer down there to the top of the producing Arbuckle zone. This is supposed to have been a temporary deal to show his casing integrity, and that we agreed if he had integrity at that point, that he would pursue and refile a UIC application permit for a new disposal. And I believe he filed it within the timeline, but it was not complete. And Mr. Noble had sent back letters requesting information, and that never got followed up. And then therefore the permit was pulled.
Okay, so I didn't mean to interrupt. Please continue.
That's all right.
Okay, so if I understand it correctly, the requirement that was unfulfilled was to reset the packer so that it is above the injection zone and below the producing zone, and do an MIT of some fashion with that configuration. Is that correct?
It was, yeah, to set the packer above both zones, shows casing integrity there. He did that. And once he knew he had good casing, he would pursue filing the new application and disposing in either both zones or however he was going to do it. But he never followed through with all the application.
Okay. I think you lost me a little bit in your previous discussion about, again, this reconfiguration stuff. Obviously, if you place, and I'm going to rely upon your knowledge of our regs too, if you place the packer in between the 2 zones and the top zone is open, you're not going to get a favorable MIT test. Is that correct?
Correct. We just wanted to show casing, and he had a high fluid level. Commissioner Keeney had a high fluid level on an offset well prior to this. I believe it was the Stumps 3 or 1. I can't remember right off the top of my head. And he dealt with that off to the side. Come to find out, he had casing leaks there. They ended up plugging that well bore. And then this one, the fluid level is relatively high. Being a dual completed well, you can't really test it with, like you said, the strings open there. So the only way we felt to show good casing integrity was to show us set a packer above the producing zone, put the open hole below it together, and then the packers above sealed off from there up to surface to show us integrity. And at that point, if he had integrity, then he knew he would move forward and file the application to make a deep disposal out of both, or however.
I got you. And it was, here's where I'm getting confused. Well, may cut to the chase as best I can. When you denied in 2021, is that correct, the TA status?
Yes, he was, the MIT was good for 3 years. And he failed. He didn't redo another one. I had to have a current one. And MIT on a TA oil well, we go 3 years, even on a UIC well, just to show us that they changed the characteristics or anything on it. And it did pass, so he refiled it and I approved it at that point. And then I denied it in 22 here with the show cause hearing.
Okay, and what was the reason for the denial in 22?
Because of the show cause hearing on this docket, the permit being revoked, or he did not fulfill his to refile everything that was requested from the UIC department.
Okay, so the field test was done, the MIT was done with the packer set above both zones.
Yeah, they left,
Is that right?
yeah, they left it in the hole since the first MIT, and that's the way it's set up today. It's the packers above both zones. They're both commingling together.
Okay, I got that. So basically, that demonstrates casing integrity from the packer to surface, basically, right?
Correct.
Okay, so the denial of the TA in 22 was because of the failure to carry forward with the documentation that you deem necessary in order to complete the application for the TA. Is that correct?
Correct.
Okay. If you could just very briefly, you alluded to a correlative rights issue. What is that? What does that mean in this case?
With the two wells, like we said, with the packer being above both zones, I'm sure after this many years, they probably have balanced out the hydrostatic levels, but whichever is greater than the other could also be forcing a what I call a poor boy flood. If the deep open hole disposal reservoir pressure is greater than the upper Arbuckle, if it's depleted, I don't know. Vice versa, it could be the other. They could be offsetting, and the oil could be going down the disposal. So, but as far as the flooding going on within the offset well, American Warrior has to the northwest of them, I believe it is, on the Langlease, it could be flooding them out, potentially flooding them out. Arbuckle's a water-driven formation. There's potential of a flood risk going that way.
I appreciate the detail.
Yep.
So basically the correlative rights issue, at least in part, pertains to concerns about the correlative rights for American Warrior, given the fact that you could have, as you euphemistically called it, a poor boy flood, basically. Is that correct?
And there's some other offset operations to the north, which they're not in the half a mile perimeter, but there are some offset production.
Okay. Couple more questions and I'm done. So again, I'm not to beat this issue too much here, but I think you're saying that the well didn't meet the criteria for a dual completion. You're concerned mainly with the absence of the documentation that's necessary here, not the field test itself.
Correct.
Okay. So if I could, we can cut to the chase here. What at this point are your primary or main compliance issues with the well at this time?
my main issues are we've worked with him for the last 5 years to get his valid lease, get the well application filed, UIC application, permit, whatever. He's has not done that. He's been getting every opportunity. Right now we have commingling going on below. Whether it's affecting anything right now, we have no evidence of it, but it's out there. So, to me, it's something I think with this well coming up in, I think the last time it produced also was 26, I believe, should have shut in. But, the other one being in 25. The Stumps 4 is also last produced in 2015. So it becomes a 10-year well as a producer also. So
I'm going to get back to that at the very end. I'm not
Yeah.
quite finished on that timeline yet either.
Yeah.
But let me ask you this. Do you believe this well should be plugged?
yes, I do.
Why?
I mean, like I said, we've worked with them for 5 years here that, something needs to be done with it. The dual completed well, the way the reg states there, it should have been ceased and plugged within, its 90-day failure to dispose and produce out of the other. When one sensation fails, they have 90 days to repair it or plug it. And we've gone above and beyond our 90 days.
All right. Is there Arbuckle production near this well? Is there within, say, a mile radius of this well? Is there Arbuckle production from other leases?
Yes, American Warriors Lang lease is just northwest of this well. It's in a section right up the coast. It's in the northwest quarter of this section.
As a general rule, are Arbuckle wells prolific water producers?
Yes, they are.
Is the water that they produce corrosive?
It can be if they have a commingling of other zones with it. Lansing, Kansas City, they create, bacteria and everything else. Water going circulating through the system, picks up oxygen, carries on down the well bore, and it's circulating around. So, anyhow.
Do many operators who have Arbuckle wells in this area, if you know, do they use chemicals to treat for corrosion?
Oh yeah, they. I'm sure American Warrior truck treats biocides and corrosion whenever you have to, or you're not going to have a well bore.
Okay. My last series of questions. I want to turn to your direct testimony, Richard. In particular, contained within the exhibits is exhibit RW4. If you could find that.
I'm sorry, Commissioner King, which testimony are you on, please?
Richard Williams, direct testimony, June 2nd. If you would look at the exhibits attached to that, Richard, it's exhibit RW-4. Correct me if I'm wrong, but this is drawn from the State Geological Survey's website, is it not?
Yes, it is.
And it shows lease production for the Stump lease. If I'm reading that correctly, it shows that the purchaser is CSHO Refinery in McPherson. Is that correct?
Correct.
Or I perhaps should say was. If I'm reading that correctly, it shows that the last oil that was sold from this was in June of 2015, and the amount was 170 and some odd barrels. Is that correct?
Yes, it is.
And we're roughly 8 years from that time at this point, are we not?
Yes, we are.
So if we then turn, I'll ask some questions about that of the operator. If we turn to the very next page. It's exhibit RW-5. You see that?
Yes, I do.
That's a UC3 that was filed for this well, this number 4 Stumps well for the reporting year of 2017. Is that correct?
Yes, it is.
And essentially, this is an annual reporting document, isn't it, that shows a whole number of details about the utilization of this well as an injection well. Is that correct? And it seems to show that, I'm not sure I heard your answer to that.
Yes, correct.
And as it shows here that the total fluid injected during 2017 was 9,424 barrels. Is that correct?
Yes, it is.
You're not the operator, but I'm going to ask you, do you have any clue as to what the source of this water was?
It could have been some outside water from an offset lease coming to it. I don't know where it would have come from, because I don't believe he had any power lines, power sources on the location of the Stumps lease. If I recall, they had that windstorm that come through, they lost their power supply.
Was the injection authority granted to the number 4 Stumps under its injection permit? Would that permit the injection of off-lease waters?
It could, if it's listed on the docket itself. Yes.
Okay. Well, it was curious to me because I know there hadn't been any well production since 2015. If we could go back to RW4 just for a minute, Richard.
Yeah.
Question. Oh, that's the survey information. Do you know where the survey obtains the information that they publish on their website? Do you know where they obtain that?
Yes, it's from the purchasers themselves. The crude oil purchasers themselves report to the KGS the loads of oil that they've hauled off. Okay.
Is it possible that the first purchasers also report the amount sold and all the other pertinent financial information, including taxes withheld, to the Kansas Department of Revenue?
Correct.
And the Kansas Department of Revenue has something to do with providing this information to this survey. Is that possible too?
Yes.
Okay. All right. Let me check. We may be there. I think for now that concludes all of my questions. I appreciate your indulgence on my questions, Richard. Thank you.
Thank you.
Thank you, Commissioner Keene. I'll turn to Commissioner French. Questions of the witness, please.
I have no questions for Mr. Williams. Thank you for your testimony.
Okay, thank you. I have no questions either. I think Commissioner Keene was very thorough in his questions. So I will turn back to staff. Mr. Kimbrell, do you have any redirect?
Yes, just a couple of questions, Chair Duffy. Mr. Williams, just to clarify, when was the agreement with Renee Stuckey and Great Plains made?
I have no paper copy of it other than what was stated on the UIC. It was in 2018, I believe.
And was there a deadline for Great Plains to come into compliance with that agreement?
Well, my recollection of the agreement when we were all talking on the phone was the 6-month ordeal to get the MIT done. If he knew he had good casing up above, that he would proceed ahead and file the application for the permit and everything to either commingle the two or however he was going to do it.
Okay, if I could share my screen really quickly. All right, Mr. Williams, can you see that?
Yes.
All right, and is this the MIT for the well from 2018?
Yes, it is.
And the note there, does it say pass in 6 months, the operator must plug, produce as an Arbuckle producer, thereby canceling docket, or reconstruct as a dual completed well per order of Renee Stuckey?
Correct. And DD is Daryl Dittman. He takes care of our UIC here in our office.
Okay, so does that indicate that there was a 6 month deadline for operator?
Correct.
And did operator meet that deadline?
He filed it, but he did not file a complete application.
All right, thank you. Talking about evidence of environmental problems or relative rights issues, do the regulations require evidence before the commission can act? No. Do the commission's regulations exist to prevent pollution and threat to correlative rights?
Yes.
Thank you. So I believe that you testified under Mr. Commissioner Keene's question that you would like to see this well plugged. If the commission decides not to order that the well be plugged, are there other steps that you believe the commission should order regarding this well?
Sealing the production perfs. If he's going to make a disposal of it, seal off the production perfs and put his packer between the two intervals and show his casing integrity that his squeeze was successful, and corrosion inhibitor and do an MIT.
Thank you. I have no further questions.
Chair Duffy, you're on mute.
I'm sorry, turning to Mr. Steinkamp, do you have recross?
Thank you, Commissioner. I just have.
Mr. Steinkamp, you might move your mic just a little bit closer to you, so it can perhaps be a little bit more clear. Thank
I'm
you.
sorry, is that better? I'm trying to. We got a lot of different things going on here. Hold on. I think maybe my mic is on my camera actually, which is aimed at my client. Is that better?
Yes, it is.
Thank you.
Okay.
Sorry, I warned you that my technical skills may be deficient, so I apologize for that.
No apologies needed. Please proceed.
Okay. Just a couple of quick questions just to follow up on some of the things that were asked. I think there was testimony that the last date water was disposed of in this well was 2017. Is that correct?
That's what he is showing. He reported on his U3Cs, correct?
Okay. And you don't have any evidence that there's any water that's been disposed of in this well since then?
No, I do not.
Okay. Thank you. Have any of the offset operators indicated any correlative rights issues?
I'm not aware of any at this time, no.
Okay. I don't think I have any further questions for you. Thank you.
Thank you, Mr. Steinkamp. I'm going to turn to commissioners. Commissioner Keene, do you have any other questions for the witness?
Thank you, Chair Duffy. Just a couple.
Okay.
Yes, Richard, I think during the course of my cross-examination of you, you alluded to a Stumps number 3 well.
Yeah, I believe that was the well. It was an offset well. That was he tried to TA and I denied it because of the high fluid level, and he ended up plugging. He was going to do an MIT, and he ended up plugging the well bore, and in the process pulling it, they found that it had a packer in a hole, and he got stuck, and we ended up, I think, shooting it off or whatever, and finished plugging the well that way.
Okay, so the well was plugged.
Yes, it was.
Okay, that's where I was just concerned about the status of the well. Follow up to one of Mr. Steinkamp's questions to you. Again, you're not a lawyer, so we'll ask this question with that in mind. But for there to be correlative rights issues, is it necessary that offset operators complain?
Yes, it is.
It is necessary that they complain for there to be correlative rights issues?
Well, if I was an offset operator, I'd be protesting it, yes.
But what if you didn't know what was going on adjacent to you? And what I'm saying, well, I'm not trying. You have to answer the question within the purview of your knowledge. So I'll just re-ask the question again. All I'm asking is, for there to be a correlative branch issue, is it necessary for operators to know that they have a problem or complain about that problem?
No.
Okay, no further questions. Thank you.
Thank you, Commissioner King. I do have a question for you, Mr. Williams. Were you contacted by the operator, for example, since 2018 on this well, on when you communicated with the operator? Did the operator communicate back to you?
I believe the communication I had through Kohler was on the denial TA. I had made an entry that I needed a current MIT, and he did perform that, I believe the following month, and then refiled the TA. That's the only, I've never talked to Mr. Fars, I believe, one-on-one. Other than in the conference call with Renee Stuckey, Daryl Dittman, our district supervisor, Case Morrison, and myself.
And that was in reference to the extension of the 6 months?
Right.
Okay.
We were all in agreement to show casing integrity. If he knew he had a good wellbore to the top perfs, that he would show his casing integrity and then file the application like he had done, but didn't fulfill all the requirements on it.
Okay. Do you work with the operator on any other leases in your area?
These are the only 2 wells he has in our district, are the Stumps number 2 and number 4.
Okay. All right, very good. That's all I have. Thank you. Mr. Williams, you may virtually step down. And I'm looking at the time. I think we're going to go ahead and take a quick 10-minute break before our next witness, Mr. Bryant, is called. Is that okay with everybody? So I see it's 10:17. Let's just make it 10:30 and we'll see everybody. Refill your coffee cup and we'll see you back. Thank you. We're off the record. We are 1 minute out, everyone. Very good. I believe everyone is back and we are back on the record. We will turn to our next staff witness, Mr. Todd Bryant, and Mr. Kimbrell, will you call your witness, please?
Thank you. Staff calls Todd Bryant.
Hi, good morning, Mr. Bryant. If you'll raise your right hand. Do you swear or affirm the testimony you shall give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Kimbrell.
Thank you. Mr. Bryant, could you please state your full name for the record?
Todd Bryant.
By whom and in what capacity are you employed?
I am employed by the Kansas Corporation Commission as the supervisor of the UIC department and production.
What is your work address?
It is 266 North Main Street, Suite 220, Wichita, Kansas 67202.
Are you the same Todd Bryant who caused to be filed in this docket direct testimony consisting of 5 pages and 7 exhibits, as well as rebuttal testimony consisting of 5 pages?
I am.
Was this testimony created by you or at your direction?
Yes.
Now that you are under oath, do you have any corrections to make to your testimony?
No.
If I asked you today the same questions contained in your testimony, would your answers be the same?
Yes, they would.
Do you swear the answers contained in your pre-filed direct and rebuttal testimonies were and are true to the best of your knowledge?
Yes.
At this time, I move for the admission of Todd Bryant's pre-filed direct and rebuttal testimonies to the formal record.
Very good. Any objection?
Objection.
It is admitted. Thank you.
Thank you. I attended the witness for cross-examination.
Okay, good morning, Mr. Bryant, and I will turn to Mr. Steinkamp for cross-examination, please.
Thank you, Ms. Duffy. Mr. Bryant, my name is Chris Steinkamp. I represent the operator in this matter. Are you aware that this well passed an MIT? It was determined to pass an MIT back in 2018 pursuant to the agreement with Renee Stuckey?
Yes, it asked the MIT above the top of the Arbuckle perforations.
Okay. And what does that indicate to you?
That the well does have casing integrity, again, above the production side of the Arbuckle formation.
Okay, so that means from somewhere at the top of the Arbuckle to the surface, correct?
Correct.
Okay. And are you aware that it also held pressure in 2019?
I do believe I've seen that, yes.
Okay. And as I understand it, the MIT was denied not because the well held pressure, but it was because it was not in compliance with the UIC permit. Is that correct?
Correct. That is correct.
Okay. And the same thing is true in 2022.
Correct.
The well held pressure in 2022, correct?
Yes.
Okay. Again, it was denied not because of its actual physical condition, but because of the permit from the KCC, correct?
Correct. It was constructed outside of the parameters of the permitted conditions.
Okay. Do you know, was it in fact constructed pursuant to the agreement with Renee Stuckey at the KCC?
It is constructed, as far as I'm aware, as Renee had as Renee had requested it be constructed for testing the casing above the perforations, but they did not follow through on the rest of the agreement.
What, yeah, but my question was, is the well
I'm sorry.
constructed pursuant to Renee's direction?
Yes.
Okay, thank you. Do you have any evidence that this well has polluted any fresh and usable water?
I do not have any evidence of that.
Okay. Do you have any evidence that this well has actually impacted any correlative rights of offsite operators?
I do not.
Thank you. Are you familiar with gamma ray neutron logs?
Enough.
I mean, you know how to read a gamma ray neutron log?
Yes.
Okay. Now this is where it's going to get tricky, because I want to go to. Have you looked at the gamma ray neutron log on this well?
I did. Grab it.
If you could identify if this is an exhibit, Mr. Steinkamp, that would be helpful for the record.
Yes, this was an exhibit that I shared this morning with Mr. Myers. It's in the public record for the KCC. It is not an exhibit to the pre-file testimony. I'm going to try to figure out how to share my screen here in a second.
Mr. Steinkamp, would you like me to do this? That's John Myers. I can display it.
That would be awesome.
Okay, hold on one moment.
Very good. John, if you will.
Okay, John, can you scroll down on that a little bit so we can see the arbuckle? It's very hard to see. There you go. Thank you. Can you guys see, can you see my pointer? Anyone?
No.
Okay.
There it is.
You got it?
Mr. Steinkamp, they won't be able to see your pointer. They can see my
Oh,
pointer.
okay.
I do not know where the arbuckle is. If you'd like to tell me where to point the mouse, I'm happy to do so if you'd like.
The top of the arbuckle is at 3335. If you can figure out where
Is that about right here?
A little below that, down another. There you go, right?
20, 30.
Right about in there.
Okay.
Another 5 feet. So right below that little blip out there that you can see, you're in the right area.
Okay.
So hold on just a second. Shuffle a couple things around here. Mr. Bryant, do you see this well log?
Yes.
Okay. And is that the well log that you looked at when you were looking at this matter or previously?
Yes, it is.
Okay. And you testified that you understand how to read gamma ray neutron logs, correct?
Correct.
Okay. And what does a gamma ray neutron log show?
Pore space density, ability for fluid to be injected.
Okay. So would it be fair to say that it shows the porosity of the formation being logged as a general matter?
Correct.
Okay. In looking at this log right now, do you see anything on this log that indicates that there is a zone in the arbuckle in this well that would create a porosity barrier between the top of the arbuckle and the bottom of the well?
I would say that from what I've looked at, what I've seen here, I don't believe that there's communication from the top to the bottom.
You don't believe there's communication from the top to the bottom?
Correct.
Based on what?
Your reports and I mean, looking at this, I guess I was looking a little higher.
John, can you show your pointer, right? You're right in the right spot. Yeah, right there. That's where the top of the arbuckle is, correct, Mr. Bryant?
Correct.
Okay. Now looking from that point down towards the bottom of the well, do you see anything that shows that there is a porosity barrier in the arbuckle?
No.
Thank you. Your testimony, which was, I think, largely adopted by Mr. Williams, indicates, I think, carefully that this well is potentially, and that's the word you used, potentially a threat to fresh and usable water. Is that right?
That is correct.
Okay. And you also indicated that this was, again, potentially a threat to correlative rights, correct?
Correct.
Okay. Potentially is a pretty big word, isn't it? I mean, isn't essentially every oil and gas well potentially a threat to fresh water?
If constructed appropriately, it would minimize all the potential risks.
Not arguing that point with you, but every well drilled for oil and gas in the state of Kansas is a potential threat to fresh water, isn't it not?
I mean, I would disagree, but I can kind of see your point.
Okay, so the answer to that question is yes, every well is a potential threat, right?
I would suppose that's correct.
Okay. Were you aware that this well was granted TA status in 2018, 2019, and 2020 by Mr. Williams?
Yes.
Okay. And if a well is temporarily abandoned, is there a continuing requirement to comply with a permit related to that well?
No, not until it's brought back into production.
Okay. And so the TA that was granted by Mr. Williams, the final one that he granted in 2020 expired in December of 2021, correct?
Yeah, it'd be a year from the date it was granted.
Yep. Okay. Were you aware that the well was again tested for mechanical integrity in February of 2022?
I do believe that.
Okay, and it demonstrated that it continued to have mechanical integrity at that point, correct?
Correct.
I don't have any further questions for you. Thank you.
Thank you.
Thank you, Mr. Steinkamp. I'll turn now to commissioners for questions, and I will begin with Commissioner King. If you have questions of this witness.
I do. Thank you. Good morning, Tom.
Good morning.
Follow up on a couple of questions. Mr. Steinkamp asked of you first, and then I'm going to ask you some other questions. I have no intention of repeating for you all the questions I asked of Mr. Williams. I don't think that would be of any benefit to anyone, but certain things are certainly within the purview of your responsibilities, and that's where I'll try to focus. Doubling back on a couple of questions from Mr. Steinkamp. So I'm going to ask you this. If you consider the totality of the permitting process for injection and enhanced recovery wells, aren't all phases of the process important that lead up to the
Yes.
grant of?
Absolutely.
Okay, so complying with the MIT requirement, while an important part of the permitting process, is only a part of the process, is it not?
Correct.
So without compliance, and I'm not trying to put words in your mouth, you correct me if you even think it's a leading question. Without compliance with all parts of the permitting process, isn't it true that you don't have a complete permitting process?
That is correct.
Because you could say, well, there's a paperwork process and there's a field part. Well, that paperwork process, I'm euphemistically referring to, that's pretty important because it provides a lot of details that may have bearing on the protection of fresh water, protection of correlative rights, and waste. Isn't that correct?
That's correct.
Another line of questioning from Mr. Steinkamp, I just feel compelled to double back on. The question was, doesn't every oil and gas well a potential threat to the fresh water? And I believe your answer was yes. My question is, how and why is that the case?
Well, I mean, you're drilling through layers. You're creating a direct conduit up to the fresh and usables. My original point to that was that if constructed correctly and cemented correctly, like the fresh and usable are well protected, and it basically eliminates the threat to the fresh and usables.
Well, you're heading absolutely directly down the line of my concern. So I'm gonna ask you some other questions, and then I'm gonna come back to the underlying question Mr. Steinkamp asked.
Mhm.
When you're drilling a well, what's the purpose of surface casing?
Surface casing is to protect the fresh and usables.
And how is that done?
Generally speaking, by drilling a set amount below the fresh and usables, cementing from the bottom to the top, and then further setting more casing in the well and cementing that in such a way that it eliminates the path to the fresh and usables.
I think that's a fair response. But let's not get too far ahead of ourselves. Let's stick with just the surface casing for a moment. So once you drill in the early phases of the drilling process, below the fresh and usable, you set surface casing in compliance with commission requirements. And no matter where you are in the state, isn't the requirement that surface casing be cemented in from bottom to top to the surface?
Correct. Absolutely.
Okay. And what's the purpose of that? Just that step.
To keep the fresh and usables where they are and to keep foreign contaminants from getting into them.
Absolutely. It isolates the fresh and usable waters, does it not? So really, I mean, it isn't just a technicality. It is, as long as that process is done in a correct way, as long as there is a cement bond, isn't it virtually impossible for the fresh and usable water to be contaminated through the drilling process?
I would absolutely agree with that.
Okay, so I'm going to re-ask the question. Is it true or not true that every oil and gas well is a potential threat to the fresh water when it's drilled?
No.
If we could, I'm going to indulge everybody, but I'll be brief about it. I'm not a geologist, but I have seen a gamma ray neutron log or two in my past. If we could bring that back up again, John, and show the Arbuckle portion of that log.
One moment.
Yeah, and John, you put your marker in the vicinity of what you believe is the top of the arbuckle.
Yes, I'm doing that right here.
Yeah, put it in the center of the log with the white spaces so we can see it. Okay, that's and Mr. Bryant, is it your belief that that is the top of the arbuckle?
I would agree with that. Yes.
And there are some marks along the vertical right-hand side line. What do those
Mhm.
what do those kind of semi-diagonal marks mean?
That, I guess, I'm unsure of that. In this case,
Is that open hole?
yes, yeah, the perfs. Okay, yeah, absolutely. Yeah, the perfs are above it in open hole.
See, here's where I'm confused. We do need to keep that a little stationary. Okay. Let's pan up a little bit further, John. Go up a little bit further. A little bit further. All right, let's just hold it right there for a moment. Now, again, looking at the vertical left or vertical line on the right, above what John had indicated was the top of the arbuckle, we have some other squiggles along that line. What does that represent?
Above in the white space in the middle there.
Yeah, above where you've identified the top of the arbuckle.
That would be, I believe that would be perforations. Or
You know, in all fairness, Todd, potentially every perforator has a different way of designating different parts of zones.
Mhm.
But when I look at that, I'm the amateur, you're the pro. That looks like perforations to me too. And if you pan on up a little bit further, John, let's go a little more shallow on the log. I guess what I'm wondering, you can stop right there, please. I'm really confused about what the top of the arbuckle is right now, to be quite candid with you. You can see that we have some more perforations up here, or what appear to be. I can ask the operator about it. I'm not trying to dwell on that. If you would pan on down toward the bottom of the log again, John. From what you identified, Todd, right there, where that marker is, right there, where that arrow is, we identified that as being the top of the arbuckle. Okay. Now, from a lay sense here, correct me if I'm wrong, the left-hand side of the log shows lithology, does it not? Whether it's a lime, a shale, a sand, or some other form of rock. That shows the nature of the rock, does it not?
correct.
And on a gamma ray neutron log, the markings to the right-hand side of the log, that indicates porosity, does it not?
That is correct.
So if we go from the top where John has the arrow, and we pan on down, you can see where down, it's impossible to get the depth readings from this scale, but you're going down a little further, John, a little further, a little more, stop right there. That's kind of a porosity break, is it not? Where you have an increase in porosity from that point down, where from that point up, it looks like it's got pretty fair porosity. Is that a fair statement?
Correct.
Okay. We're done with that. I'm done punishing everybody with that. Todd, let's take a look at, I'm looking at, you need not show anything here, John. Todd, I'm looking at your pre-filed direct testimony of June 2nd, 23. In particular, let's take a look together at, it's really the first exhibit. I'm trying to find where it's marked. I'm not sure that it is. It would probably be exhibit TB1.
Okay.
What is that, Todd?
I believe if I'm correct, I believe we're looking at the original application.
Actually, it's the original order of the commission, isn't it?
Order, yes, correct. Sorry.
Yeah, this is the order of the commission granting the permit initially. And they date, and it's granted, if you look at that, just below the where it says order, it was granted on the 29th day of May, 1964, right?
Yes. That's correct.
By my reckoning, that's 59 years ago. Is that correct, roughly?
I'll take your word for it. Yeah.
So the well had to be drilled. Maybe it was drilled just before this was done, but the well's at least 59 years old.
Yes.
Well, why is that relevant? Well, let's go on down and look at the terms of the permit. Because this is the permit, is it not, for the disposal of water into the number 4 stump well. This is the well that's before us this morning.
That is correct.
Let's look at under the order, part F of the order.
Okay.
That provides casing information, does it not?
Yes, it does.
And the surface casing is the 10 3/4, isn't it?
Yes, it is.
And it shows that it was seated at 277 foot, cemented to the surface with 150 sacks. Is that correct?
That is correct.
More importantly, though, let's look at the production casing. That's the 7-inch casing that is set near the TD at 3,441 and change feet, right?
Yes.
The casing, when it was put in, notice the condition. It was used casing in 1964. Okay. Go over a couple of columns and it shows the estimate of the amount of casing that is cemented. It's cemented 500 feet from the bottom. That's what that means, isn't it?
Correct.
Because they only used 100 sacks of cement.
Mm-hmm.
So what that means is, doesn't it, that this used strand casing has no cement that protects the outside of the casing from all of the elements inside the hole from 2,941 feet to the surface. Is that correct?
That is correct.
Wouldn't that be a potential threat to fresh water?
Oh, absolutely. In this area, to today's standards, we require at least 300, well, yeah, at least 320 feet of surface casing cemented to surface, which would put this shy 40 to 50 feet ish.
Okay. Appreciate that embellishment as well. Let's take another look at another section of the order granting this permit. Let's look at subsection G. And for the record, I'll read it in. You follow along and see if I read correctly. It says that what this has to do with is the source of the water that's going to be injected. That's what this has to do with. It says that salt water desired to be introduced will be produced from the following described wells and leases. And then it shows the lease owner at the time was Floyd W. Smith and Company. It shows the lease being the stump, shows the legal description of the lease that's in the well that's before us now. And it identifies 4 wells at that time that were able to provide water into the to be provided to be injected. Isn't that correct?
That is correct.
Let's go on over to subsection H on the next page, and under the it is therefore by the commission ordered under the ordering section there. If you go down about 6 or 7 lines, it says that the water is estimated to be 100 barrels per day minimum to 900 barrels per day maximum. That's the injected volume in the original permit. Isn't that correct?
Correct. In the original permit, that is correct.
And so if we turn the page and we go over to exhibit TB2, it looks like in 1989, the commission at that time granted an increase in the production of injected water up to 1,500 barrels per day. Isn't that correct?
That is correct.
And if we go on to the next that's 2 pages over again. Again, it's exhibit TB2, page 4 of 6. It appears that in 1991, the commission again increased the injectable quantity of fluids to 3,000 barrels of water per day. Is that correct?
That is correct.
Is that the allowable injection amount now as of today?
Correct. Yeah, it would be 3,000 barrels at gravity.
Okay. while we're talking about the well here in this context, I have to apologize to my colleagues here. I may have to briefly ask that Mr. Williams be recalled, because I'm going to ask you a question, Richard, that you may not know. You cover a wide range here. You're responsible for basically the state. Mr. Williams has a lot that he's responsible for, but he's more familiar with the conditions in District 4.
Yes.
Do you know, in the vicinity of this well, do we have any of these super corrosive producing horizons below the freshwater and above what the Arbuckle zone is, like the Cedar Hills or any other comparable, really terribly corrosive waters? Are you familiar with whether or not that exists in the area of this well?
I could not.
I don't know what super corrosive even means, honestly.
All right, corrosive.
Hold on,
I-
we had someone else speaking there for a moment.
Yes, so if we could all mute our microphones, and Commissioner Keen is asking the questions of the witness. Thank you.
Thank you. Last time I checked, I wasn't under cross-examination. You could go ahead and answer, Todd. I'm sorry.
No, I could really only be guessing on it. I'm not 100% familiar with that.
No, we don't want you to speculate.
No.
Okay. All right, bear with me. Why do you believe this well should be plugged?
I believe this well should be plugged due to the fact that they've been given ample time to comply with our requests, ample chances, and have failed to do so. As operating in good faith, I would say that that's not really applicable anymore with what's been done. Even in the past, when they did submit an application, requested for information, or information was requested and never followed up on. So, I mean, at this point, I believe that they've had enough time to correct the issues and move forward.
All right, thank you. Bear with me just a moment. Let me look at your testimony. Pre-filed. I appreciate your indulgence and the commission's as well. I believe that concludes all of my questions at this time. Thank you, Tom.
Thank you.
Thank you, Commissioner Keen. Commissioner French, do you have questions of the witness?
I have no questions. Thank you.
Okay, thank you. Good morning, Mr. Bryant. Just quickly, have you ever visited with the operator on any issues related to this particular lease?
No, I have not. All communication was done with my predecessor, Renee Stuckey.
Okay, and when it comes to the oversight of ensuring that the operator is adhering to the rules and regs and the laws of the state of Kansas, are you ever in conversation with, you're in the office in Wichita, correct?
Correct.
Are you ever in conversation with your fellow employees out in the district?
Yeah, we do speak frequently.
Okay. Do you act autonomously, or do you share information on your issues and concerns with, for example, like Mr. Williams in this particular lease and well?
I do confer with district staff and share information back and forth. Yes.
Okay, all right. Let me look here. I think that's all my answers. I do appreciate Commissioner Keen walking us through the historical aspect of, I mean, it's not often that we go back to 1964 to begin discussion with the well. So I do appreciate that. Thank you, Mr. Bryant. That's all the questions I have.
Thank you.
So I will turn back to Mr. Kimbrell for any redirect.
Thank you. Mr. Bryant, to clear up one issue that was brought up with Mr. Williams, are there any offset operators allowed to inject fluids into the Stumps number 4 under the injection permit?
No other operators outside of the Stumps lease. The 4 wells 1, 2, 3, and 4 are authorized to inject into that well.
Okay, thank you. Mr. Steinkamp talked about the Stumps number 4 holding pressure when an MIT was done above a packer placed above the production perfs. Is that correct?
That is correct.
Okay. Doing an MIT above that packer, above the production perfs, does that tell you anything about what's going on below the production
Absolutely
perforations?
not. Sorry, no.
Renee's instruction to Great Plains for how to construct or reconfigure the well. You mentioned that Great Plains put the packer in place. Is that correct? Was that your testimony?
Yes.
Was Renee's instruction meant to be a permanent solution, a permanent construction for the well?
No, it was meant to be a temporary to test the casing above it and then either plug the producing perfs, plug the well, or produce and inject. Return it to service, excuse me.
And we kind of got into semantics earlier. Would you rather deal with potential threats to the environment or actual threats that are occurring that are harming the environment?
I would much rather deal with potential threats instead of waiting until they become apparent.
Are the commission's regulations meant to deal with potential threats?
Yes.
I'd like to share my screen. All right, Mr. Bryan, can you see this letter?
Yes, I can.
And is this a letter from Great Plains Petroleum?
Yes, it does.
And was it sent to the KCC?
It was.
And is it signed by Mr. Ferries?
It is.
Chair Duffy, I'd like to admit this as staff's exhibit number 1 into the record.
Any objection? Seeing none, it is admitted.
Thank you. I'm going to read this second paragraph here. We have also injected fluorescent dye down the disposal string on 4 separate occasions. No dye has been observed in the produced water. Can you explain what that means?
That would essentially mean that there would be no communication from the production to the injection portion of the arbuckle.
And when you say that, you mean outside of the well, there's no movement of
Within
water
the formation.
within the formation. Okay.
Correct.
So is Mr. Ferries essentially saying that in this letter that there is no communication between the upper and lower arbuckle in the formation?
Correct. That's exactly what he's saying.
Okay. If there is a well that has an open disposal zone and open perforations, one in the lower arbuckle and one in the upper arbuckle, is it possible for that well to cause communication between the lower and upper?
Absolutely. If it didn't have communication before, by putting a well bore in and setting a packer above both sets of perfs, it has created a direct path to communicate.
Stop my screen share. I wanted, hoping for a bit of clarification. What are your concerns with the surface casing for the Stumps number 4 well?
The surface casing is a concern due to our current rules and regulations. I would say that the surface casing is possibly set above the base of the Dakota, which would allow fluid to travel up the annulus behind the production, behind the production casing and into the Dakota.
Okay. If Great Plains were to apply today for an injection permit for the Stumps number 4 well as a saltwater disposal well, would you approve that application?
Not as it sits today.
And why is that?
well, the surface casing would be an issue. We'd have to do a surface casing exception. To be a disposal, we'd have to plug off the production side of the Arbuckle to top perfs, run a packer down above the injection part of the Arbuckle, make sure the squeeze job that was done into the production side holds. We have mechanical or casing integrity, and then they'd have to fill the backside with corrosion inhibiting fluid and do an MIT.
Can you explain a bit when you said squeezing into the production perforations? What does that mean?
Yep. As it sits, the production, there's 5 feet of perforations in the top of the Arbuckle. They would have to go down and essentially close off or squeeze cement out into the formation to eliminate those perfs and effectively shut off that portion of the Arbuckle, or seal it off, excuse me.
Is there any chance that doing this squeezing of the cement would essentially destroy the well, ruin the well for any future use?
I could see no way that would ruin the use of the well.
If the commission were to order the production perforations to be sealed off, would this well still be classified as a duly completed well?
No, it would not be.
All right, so it would no longer be a duly completed well if the commission ordered those perforations to be sealed.
Correct.
All right, I think that's all the questions I had. Thank you.
Thank you.
Thank you, Mr. Kimbrell. Turning back to Mr. Steinkamp for recross.
Yes, thank you, Commissioner. A couple of questions here. Hold on, I gotta find my notes. I apologize. You talked about the surface casing. If this well were drilled today, you believe that the commission would require 320 feet of surface casing rather than the 277 feet of surface casing that was actually installed in this well in 1964. Is that right?
Yes, that's correct.
Okay. Is there a way to go into this well and extend the surface casing?
There is not. You would have to perform a backside squeeze, either through sticking a 1 inch down the backside of the production casing and squeezing from 320 feet to the base of the cement, or perfing it and squeezing it up there.
Okay, so what you're saying is that the way you'd go fix this would be to go shoot holes in the casing at the freshwater zone and squeeze it?
So that was one of 2 ways. The other way would be to stick 1 inch down the backside and get your cement in that way.
Down the backside of what?
The production case, the annulus behind the production and beneath the surface.
So you would have. Does the KCC require operators that have old wells to do that routinely?
If old wells are being brought into being used for new permits, absolutely. This well was grandfathered in before it lost its injection authority, is the only reason it was allowed to operate the way it was right then, or until then, excuse me.
Okay, so it's your testimony that if a new permit was sought and granted, the commission would require most likely the 1 inch cement emplacement methodology that you described.
Yeah, it would require some remediation work, not remediation, excuse me, some a surface casing exception, in whichever way it would be most appropriate to complete.
Okay. And presumably, absent anything else related to this well, if this was a your other issues that have been raised in this matter were not present, and somebody came to you with a well like this and asked for a surface casing exception, based on your testimony, that would likely be granted by the commission.
We would have to do some further review, but it's quite possible, yeah.
Okay. And let me ask you this, we looked, and John, if you can flip that log up for just a second again.
Yes, one moment.
Okay, can you see that?
Yes, again.
Okay. You talked with Commissioner Keene about the little cross hatches in the center white area of the log, right?
Mhm. Yes.
Okay. Does it appear to you that somebody has handwritten those on this particular log?
Yes, it does.
Do you, in actual fact, know what they were showing when they made those marks on this log?
I do not. Not
Okay.
100%.
Okay. And I think somehow there was speculation that those were perforations.
That was, yes.
Okay. But we know where the perforations are, don't we not?
The ones that have been reported correct, yes.
And so, all of these marks on this log do not correspond to the perforations in this well, do they?
No, they do not.
Can you see that little scale that's kind of in there? It's about at 3,300 and it's kind of across the log, across the face of the log. Do you know what that means?
That looks like the porosity scale.
Okay. Can you tell kind of what the range of porosity is in this well using that scale?
I can't make out the numbers now.
Okay. The letter that, thanks, John, you can take that back down. The letter that Tristan asked you about from December 12th of 2013. Were you in your current position at that time?
No, I was not.
Okay. And the letter is to a Mr. David Wan. Do you know David?
No, I do not.
Okay. So presumably you didn't talk to David Wan about what he thought this letter meant.
That would be correct.
Okay. And so I guess it's your speculation that this letter is designed to show that there's no communication between the open hole and the perforated zones in the well. Is that right?
That's what I would take that letter to say, yes.
Okay. But you don't know that, right?
Nope, that's just my interpretation of the letter.
Okay, thank you. Let me ask you this. You indicated that if this well was to be returned as a disposal well, that it would be required to squeeze off the production perforations. Is that right?
Yes.
Okay. And the way they do that is to put tubing down the well and and put cement into those perforations under pressure. Is that right?
I am not. I have never taken part in this, but that is my understanding, yes.
Okay. Is there other potential uses of this well besides as a disposal well?
I mean, I'm sure there are, it's not really up for me to decide.
No, I'm not asking you to decide. I'm just asking you if there are other potential uses of the well.
Yeah, I'm sure there are.
Okay. I mean, for example, could this well be converted to an EOR well?
Quite possibly, yeah.
Okay. And if that were to happen, you would not want to squeeze off the production perforations, would you?
If you're completing it as an EOR, no, you wouldn't want to squeeze off the purse for the production side.
Hold on 1 second. One last question, I think. Are you aware of any water being disposed of in this well from any other well besides the Stumps wells that were permitted?
I am unaware of any. No.
Thank you. That's all I have.
Thank you, Mr. Steinkamp. I'm going to turn back to commissioners. Do you have any follow-up looking at Commissioner Keen?
Very briefly, Todd, again, in that colloquy that you had with Mr. Steinkamp, in the event, under whatever circumstances, they were to try to run 1 inch, as you suggested, down the annular space between the outside of the production casing and the inside of the surface casing, or down in that extra space that you think under current regulations it would need to be cemented to get down that far. If that process was actually undertaken and they actually spotted that cement at that point and did that, can you think of any possible complications that having done that would cause if the well ultimately were to be plugged?
That last part confused me. Can you say that again? I'm sorry.
Yeah, if they actually conducted that procedure so that they could basically enhance the protection and reduce the risk of contamination of fresh and usable waters by use of cement from the base of the existing surface casing down to a lower level that's required by our regs. If they were to actually do that successfully, can you think of any complication that might cause in the event the well would ultimately be plugged?
No, not really. I guess.
Not intended as a trick question, but if they did that,
Yeah.
wouldn't that interval be permanently cemented into the earth?
Yes, that would absolutely be.
So that if they were going to draw any casing right now, where they could shoot off the casing down to some point in the vicinity of 2,940 feet, where they estimate the top of the cement is right now, and they could draw that casing out, and that may have some salvage value, as high as steel prices are today. But that would be virtually impossible if they did that, would it not?
Oh, absolutely.
Okay, that was the only thing I was getting at there. No further questions. Thank you. No further questions.
Okay, thank you. Commissioner French, any follow-up? All right, thank you. You may step down, Mr. Bryant, virtually. You may step down. Appreciate it.
Thank you.
If I could visit with Commissioner King, you had mentioned bringing back witness Richard Williams. Is that your intent, and would you like to do that now?
I can't thank you enough for your thoughtfulness, Chair Duffy. I think, yes, I would, and this would be the appropriate time. It's for the very limited purpose of asking him just one or two questions, just a very limited purpose. I think this would be the opportune time, no.
Okay, very good. Mr. Williams, we're calling you back up to the stand. Please remember that you are still under oath. And I will turn to Commissioner King for a follow-up question.
Thank you, Chair Duffy. Richard, have you been present throughout the cross-examination of Mr. Bryant?
Yes, I have.
I directed a question to him that probably I should have directed to you, and I apologize to both of you for having not done it before. But in the vicinity of, I went through with him the original order and the data that's contained within the order that pertains to the amount of casing that was used and cemented in place when the well was originally completed. Do you remember that testimony?
Yes, I do.
And it appears, if my math is correct, that from approximately, because they only used 100 sacks of cement from the bottom of the well, that they would only have covered, by their estimate, approximately 500 feet from the TD of the casing up into the hole that would have actually been cemented into the earth, so that the interval from basically 2,940 some odd feet to surface would of the production casing would not be cemented in place. Do you recall that?
Yes, I do.
And so I'm sorry for all that lead up. My apologies to all. But the question I'm really getting at is, I know different areas of District 4 have very problematic and very corrosive water zones, incredibly corrosive water zones, whatever the adjective, I don't care, it doesn't make any difference. Do any of those zones exist, to your knowledge, in the vicinity of where this well is? And if so, what are those zones?
Well, I mean, anytime you have a field that's this old, I mean, there's some 40s and 50 wells down there drilled in the 40s and 50s, and this in 64. You're going to have a multiple corrosion problems because the water's been around and around, basically circulated around. I mean, it's you're going to have problems no matter what. With Kansas City breaking in on other wells, Dakota leaks offset wells, that migrates through the Kansas City perfs, Arbuckle, whatever, flooding them out until it's caught and squeezed off or plugged off. So, yeah, I mean, this old of a well bore, you have high potential of corrosion no matter what. I mean, the well's been sitting dormant, so you have salt water below this packer to the open hole. It's still a casing interval. I mean, there's casing set below it to the open hole. That's been exposed to the corrosive salt water all this time. Who knows? And it was used casing to start with, so you don't really know what you're going to get into below that packer as far as cementing it off and everything else. But you probably have to run a scraper, clean it out, run tools, set a plug to keep the cement. You got 101 foot between your top Arbuckle perfs to the open hole completion for the disposal. If you can find a good area, set your plug and sand it, and then pull your packer up above your top production perfs and squeeze it off. But like I said, as old as these well bores are, it's like a car, they wear out too. So, I mean, the corrosion's there no matter what. From prior history with an offset well that was broke in, I would say it's probably very corrosive down there.
Well, thank you for the very granular response to my question. I appreciate it. One brief follow-up. When the packer was set for the last MIT that was conducted above all of the open zones, was the hole filled with fluid for the MIT? Do you know?
They did that back in 18, and it's never moved since. I the ECRS that did it was not there, is not with us here at present. I'm not familiar if they circulated. I would hope they did, corrosion inhibitor and biocides, whatever. Mr. Fars could probably answer that question to us.
Okay. Was that Bruce Ruddy?
I think Bruce was gone at that time. Well, Chris Neely ended up getting dispatched to go down and catch it, but they already had it set and was getting ready to pressure it up. So I'm not familiar if it was noted on the MIT or not.
That's okay. You need not look it up. That's fine. You need not. Am I correct that the final question, that the MIT testing pressure was what, 300?
Yes,
minimum?
it was. Yes.
Okay. No further questions. Thank you so much, Commissioner Duffy. I appreciate your courtesy.
You're welcome. Okay, very good. Mr. Williams, you may virtually step down as well. We are going to go ahead with operator's witness, Mr. Steinkamp. Would you like to call your witness?
Yes, thank you, Commissioner. I would call Roderick Ferries. Mr. Ferries, and he's on the screen now, and my mute is off, so I think he'll be able to answer correctly. Could you please state your name for the record?
Roderick Ferries.
And you pre-filed direct testimony in this matter, did you not?
Yes.
Was that testimony prepared at your direction?
Yes.
Okay. And if we were to ask you all those same questions today, would your testimony remain the same?
Yes.
Okay.
Mr. If I could swear the witness in.
Oh, I'm sorry. I jumped ahead of you.
Yeah. Mr. Ferries, if you'll raise your right hand, please. Do you swear or affirm that the testimony you shall give today is the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. Mr. Steinkamp, you may continue with your witness.
I apologize for jumping ahead of you.
That's all right.
Well, Mr. Ferries, I asked you a few questions before you were sworn in, and you answered those questions. Now that you're under oath, are those answers still the same?
Yes, they are.
Thank you. So, and we've talked about your testimony that was pre-filed, was prepared by you at your direction, correct?
Correct.
And if you asked those same questions today, you would say the same thing, correct?
Correct.
Okay. Is there any corrections that you would like to make to any of those answers?
No.
Okay. Is there any additional things based on what's happened here today that you may wish to add to your testimony?
I can expand on points for clarification, but I don't know at what point.
I understand.
Okay.
Let me ask you,
Mr. Steinkamp, are you going to request admittance of Mr. Ferry's testimony?
yes, can I move that Mr. Ferry's pre-file testimony be admitted to the record?
You may. And is there any objection to that? Hearing none, it's admitted. All right, you may continue, Mr. Steinkamp. I think we've got the formalities out of the way.
I apologize once again. There was some conversations had concerning a letter that you sent to the commission in December of 2013. Did you hear those questions, Mr. Ferry?
Yes, I did.
And this is your letter, correct?
Correct.
Okay. Could you explain to the commissioners what that letter says and what it means?
I'm going to object. Chair Duffy, I believe this would be better at redirect. I believe cross-examination of the witness should come first.
I would agree. And so if we could continue, Mr. Steinkamp, with our direct.
Sure. I was just trying to get him to explain, perhaps to save a bit of time, but that's okay.
Okay,
Hold on one second, excuse me. Well, there's no other direct testimony that you need to add to what you've pre-filed at this moment, correct, Mr. Ferris?
As much as I understand the hearing process, I don't believe so.
Okay, thank you. Well, and I'll tender for cross-examination by Mr. Kimball.
very good. Turning to Mr. Kimbrell, cross-examination of the witness, please.
Thank you. And thank you for being here, Mr. Ferris. So do you currently have a lease for the Stumps?
Partially.
And what do you mean by that?
I believe we have a valid lease from one landowner. And as we tried to acquire more leases, we had people responding, they didn't know if they owned the minerals. They thought they did, but their brother-in-law was fighting with them over it and things like that. So that's why on Richard's testimony, do you have a valid oil and gas lease? There was a period where on the TA application, I checked the no box, as the KCC said, and then when we got a valid lease, then I went to checking the yes box, that a valid lease does exist on the subject acreage.
Okay, so you believe at this point in time you have a valid lease?
But once again, partially, yes.
Can you legally be on the property?
Yes,
And you can legally work on the subject well?
yes.
Okay. When did you first take possession of this Stumps number 4 well?
Boy, I'd have to look at the T1 90s. I would say. I'm sure it's in the record.
Okay. And since that time, what years have you had a valid lease?
Until whatever time the cessation of production would have made it such that a landowner could challenge and get adjudicated that the lease was no longer valid.
And when did the cessation of oil production occur?
2017.
The KGS records that we've looked at before showed that there's been no oil production since 2015.
No oil sales since 2015.
So you've produced oil since 2015, but not
Yes,
sold it?
we were making small amounts of oil to the gun barrel and to the stock tank as we continued working on the lease.
And what have you done with that oil since 2017?
Sitting in stock, I believe.
So since 2017, there's been oil sitting in a stock tank. Do you believe that constitutes an environmental threat?
I don't know if there's oil there, but that certainly could be a threat, yes.
So you haven't been on the lease to check if there's any oil in the tank? Is that what you mean?
Yes, I do not know the oil gauge on the tank.
Okay. So I believe we discussed that last oil sales was 2015, last oil production was 2017. Yeah, did you last inject fluids into the well in 2017 as well?
Correct.
Okay. And so we had some discussion about where the water came from that was put into that well in 2017. Where did that water come from?
The Stumps lease.
Okay. So in your testimony, I'm going to go ahead and bring up the testimony. I'll do a screen share. So on page 3, line 1 of your testimony, can you see that the testimony, Mr. Ferris?
Yes, I can.
Okay. You stated that eventually oil production naturally declined to the point that economic amounts of crude oil are no longer capable of being recovered from the production string. When did that occur?
The Stumps number 4 kept making dribs and drabs of oil, and then would water out. It was pulled down. So somewhere in that interval, 2015 to 2017, I would say.
All right. I'm going to pull up the commission's regulation 82-3-404. Can you see that?
I can see it. I can't read it very well.
Let's see.
Let me see if I can make it bigger on my screen for him.
Okay.
Is that better?
Yeah, it's legible to me, I think.
I made it all
Mr.
bigger.
Kimbrough. Yeah.
Okay. I'm just going to read section C, where it says cessation of production from duly completed well. Upon cessation of commercial production from the producing interval of a duly completed injection well, the injection authority shall be canceled by the Conservation Division unless the operator, through the filing of a modification, shows all the following: the perforations at the producing interval are sealed, the casing above the injection packer has mechanical integrity, the tubing casing annulus is filled with the corrosion inhibiting fluid. You stated that in between 2015 and 2017 that there was a cessation of production from the duly completed well. Did you inform staff of this fact?
I have telephone conversations with District 4 staff. I don't recall the exact content of those conversations, but
Do you recall? Sorry. Oh, sorry. Go ahead.
but when they said, hey, we need to do the MIT well, then I said, we need to MIT the well. I said, it's not going to work the way it's been MIT for the last, 45, 50 years because of the production being down. So then I believe that's when I started having the conversation with the UIC director, Stuckey, then. And like you guys have stated, the most important thing is, casing from 1964 and protecting it. So we said, let's move the packer up to the point where we can conduct an actual mechanical integrity test. The other ones were called a mechanical integrity test by the KCC, but that's like a descriptor because they weren't actual mechanical integrity tests. It was a proxy for a mechanical integrity test. So we changed the configuration of the well such that a valid actual mechanical integrity test could be performed to check the status of the casing, and everything was still protected at that time.
Okay. But did you seal the production perforations on the Stumps number 4 well?
No, we did not.
Did you conduct an MIT above a packer directly above the injection zone?
Yes.
Above the injection zone?
Oh, directly above the injection zone? No, above the producing zone.
All right. Did you put any corrosion inhibiting fluid into the tubing casing annulus?
We did on one of the MITs, but not the most recent one, I believe.
All right. Is it your understanding that if you were to apply for the Stumps number 4 to be a disposal well, that you would need to take all of these 3 steps?
Correct. Yes.
Okay. I'm going to turn back to your testimony. And I'm going to go to page 5, line 15, starting at line 14. You state that you plan to drill a new Arbuckle test well on the subject acreage. Producing Arbuckle wells in the area require a saltwater disposal well to make production economically profitable. The cost to drill a new well would exceed $300,000. So in your testimony, your plan is to use the Stumps number 4 as a disposal well. Is that correct?
Actually, we would like to use it as an enhanced recovery well.
Is that anywhere in your testimony?
I don't think I got asked that, but it's to my recollection, it's not in my testimony.
Okay. If you were able to use the Stumps number 4 well as an EOR well, you wouldn't have to seal the production perforations. Is that correct?
No, I want to inject into the top of the Arbuckle. That's where the residual oil is. on the Stumps lease and the entire area of the sector. That's why the gel technology treatments in the Arbuckle work, is because we've got a large, at the very top of the Arbuckle, there's a huge amount of residual oil that's unswept through that area. So that's actually the target of the EOR well, is to sweep the oil zone at the top of the well. And the Stumps number 4 is a little low. So to higher Arbuckle wells, it'll be a slight upward sweep, which helps when you get some oil mobilized, that it tends to move to the higher wells.
All right, and perhaps I said my question poorly, but I asked, you would not need to seal the production perforations.
Oh, I misheard. I misheard the not then, Mr. Kimbrell. So rephrase it again so I can answer exactly as you asked the question.
Sure. So if this Stumps number 4 well was approved as an EOR well, you would not need to seal the production perforations. Is that correct?
That is how I would do the application. Yes, I would do a new disposal application to inject into that zone as a completely new EOR saltwater disposal.
And how much would it cost roughly to seal the perforations in the production zone?
I don't know, 30,000 probably. You know, we've got disposal string in the well, so that can't be used. You have to move a working string, and the Arbuckle is hard to get a good squeeze in because it has so many different kinds of unconventional porosity. So if the cement's going into a large set of fractures, it doesn't go into the matrix dolomite porosity. So it's very difficult to get a successful squeeze to 100% in top of the Arbuckle producing zones. Just it has so much secondary porosity due to subaerial exposure that it's a very complicated pore network there.
So if the Stumps number 4 was approved as an EOR well, you'd be saving yourself $30,000 basically. Is that correct?
Correct. And have additional oil recovery.
And have you performed studies to indicate that an EOR would actually result in additional oil recovery?
Yes, there's numerous areas in the Arbuckle that they use gel technology in the perforations. And as you reroute the existing water zones, the water moves through different flow paths, and that mobilizes residual oil. So there's numerous studies in the state of Kansas of the general feasibility of that idea for the Arbuckle. There's no study that could be done to say it will work on the Stumps because that's very site specific. So I hope that answers your question.
Where would you get the water from for an EOR flood?
If we drill a new well, then we would just use existing lease water. And it'd be Arbuckle water going back into the Arbuckle, which has the least reactions with the formations.
So can you tell me where the Stumps number 4 well has a packer right now?
It's on the MIT, like about 45 feet above the top of the Arbuckle. Packer set at 3293.
Okay. Are there any obstructions in the Stumps number 4 well below that packer?
I can't recall. There was a permanent style packer. So there may be a packer that you can sting into that has open receptacles. So, or that may have been removed when we pulled the long string on the disposal well. Let me think, 1964. No, I'm pretty sure there is a Baker permanent packer set, it's probably on the original order where the packer was. So there is a partial obstruction below that. So there's a open flow path, but I'm pretty sure a Baker permanent packer in there.
And would having an obstruction make it more costly to plug the well?
I don't think so. I think in beneath the cement, the plugging order would just be put cement in that through the zone, since the obstruction is a partial obstruction. It's an obstruction to getting full casing diameter tools to the bottom of the well, but not an obstruction to getting tubing access to the bottom of the well, if that answers your question.
Yeah, I believe it does.
Okay.
I'd like to go ahead and bring up the letter that we discussed earlier. I wanted to discuss that with you as well. So let me pull that up. Can you see that letter?
I have a paper copy. Thank you.
Okay. And you did send this letter to the KCC in 2013.
Correct.
Is that correct?
Yes.
Okay. And so what we're interested in is that second paragraph where you talk about injecting fluorescent dye and then no dye was observed in the produced water. Can you explain what you meant by that?
Yes. Mr. Kimbrell, I think it'd be helpful, since this question was asked. I believe David Wan was the predecessor of Mr. Stuckey, who's the predecessor of Mr. Bryant. Do you know the lineage of that? That may predate your time by a little.
Yeah, I'm afraid that predates my time. Yes.
Okay. So I think the letter, that's my recollection, but I'm not going to state with certitude. So the MIT requirement for the state on a dual completed producing and disposing well at the same time clearly is not as I've got a mental blank on the word I want. It's not as direct evidence of proof of integrity, like when you put 300 pounds on it and it holds. So basically, the fact that you're still producing oil from the oil zone means you don't have a gigantic casing leak, or that wouldn't be the case. There'd be a chance you could have a very small casing leak and you were just producing that water with it. And that's why they take the water analysis. And then the most likely failure point on that is that you're starting to get leaks in your disposal string or the long string. So we injected the fluorescein dye into the well to see if the disposal string or the packer seals at the bottom were not holding. And then the producing well would have captured that dye very quickly at that time and shown truly, if we didn't have the part of the mechanical integrity of the well that was testable, we were testing by that process. So the fluorescein dye, if the seals in the seal bore receptacle of the packer, or if the long string, the disposal string itself, was getting small leaks, that was the mechanical integrity test, was to inject dye.
Okay. I'm afraid I'm not a geologist, so you're going to have to explain this to me like I'm an idiot. So when you put the fluorescein dye down into the disposal zone, where did the dye go at that point?
The dye went out in the open hole portion out into the Arbuckle Formation.
Okay. And so if you had seen that fluorescein dye from your produced water, would that indicate that the dye had gone up through the Arbuckle?
So to to start to do a primer on it, no, it would not have gone through the Arbuckle in the normal formation in the normal sense. An Arbuckle well, there's a matter, it's just a pure question of volume. So an Arbuckle well, I just, to do a quick estimate, the 100 feet of Arbuckle formation with a 10-acre spacing is like the smallest drainage thing you use, and 18% porosity. The Arbuckle volume being accessed by the perforation at the top is 1.4 million barrels of water. So under normal circumstances, injecting that dye in there, if the formation was communicated, yes, we would see it after we had pumped, 500,000 or 600,000 or 700,000 barrels. We might start getting a recovery of that dye if the well is in communication.
And did you ever get any recovery of the dye?
We quit monitoring it. The pumper goes and pulls samples for a couple days, because if it's a mechanical failure, it comes around quickly. And then, so that was the primer. The other way it could come around would be if there were channels in the cement outside of the casing, or if there was a fracture job on the Arbuckle, or, and the Arbuckle has this, in certain places, it has vertical fractures that have been enhanced by percolating surface waters. And those have given the Arbuckle very high vertical permeability, which is the reason the KCC used to have the production limits on it, because that formation is very prone to coning, that if you're pulling oil at the top, you can get water to come through your oil zones and come into your producing zone that way.
Okay, but the fact that you didn't see it would be evidence that there was no natural communication, correct?
If I pumped 1.4 million barrels and then didn't see it, then yes, that would be evidence. Short of pumping that much fluid, the volume of water down there is so vast that even being in communication, you would not see the amount of dye that we put in during the life of the well.
Okay. The way the well is constructed now, where the disposal zone is open and there's open perforations, the producing perforations are in the upper and the disposal is in the lower. Can the well, the Stumps number 4, act as a conduit to mix upper and lower Arbuckle water?
I don't believe there is such a thing out there as upper and lower Arbuckle water. It's a common source of supply. It's got 113 feet of relatively homogeneous porosity on it. So I believe it's one complete packet of water in permeable rock. A thin oil cap develops on the top of the seal. Usually the Simpson Shale is the seal. And that's the only difference, is there's a thin oil cap at the top of the Arbuckle in this area.
All right. Would there be movement of water between the upper and lower then?
No, there has to be a pressure differential.
And is there a pressure differential?
No.
How do you know that?
Because there's 20 million barrels immediately adjacent that would immediately dissipate any pressure differential.
But you just said that it takes a long time for any kind of movement of the dye. So how could there be instantaneous pressure differential being lost?
Because of all the acreage around it. I mean, there's 500 trillion pores in the acres, and the dye went out to a few in the bottom. And in drawing the 10 acres, we're drawing fluid from such a gigantic area that it's all tied together, and there's not a direct pathway. You would literally have to, if you put something in the bottom of a straw that's 20 miles long, you would have to suck 20 miles out of the straw till the pea reached your mouth. But you wouldn't say the pea's not connected to the mouth of the straw. The pea's going to get there eventually, but you got 20 miles of water in your straw that you got to draw first. Does that clarify?
I think I understand what you're saying. Yes.
Okay.
So if I guess I'm still confused though about the differential in pressure. Why do you know that there is no differential in pressure? Why do you know that it's upper and lower Arbuckle water may not, or the water from one zone might not be moving to the other zone?
Because nature abhors a vacuum. You can't have a pressure differential in an open system. And the top of the Arbuckle with 25% porosity covering acres and acres, I mean, we may be in the center of 10,000 acres of porous and permeable Arbuckle. So, you know, as soon as you quit drawing on the well or inject, so while you're injecting on the well, there's a tiny pressure differential down at the open hole where water was going in, and it dissipates very quickly, you know, within feet of the wellbore probably. And the same thing when you're producing, you're pulling and you're making a pressure differential as you're extracting fluid. And the entirety of the Arbuckle is trying to refill that pressure differential, which is why the wells have coned and everything, is because, you know, water's trying to come, oil's trying to come in, whatever you're making a pressure differential of, which is just the opposite of a pressure solution reservoir that you can deplete. Arbuckle wells don't deplete of fluid, they deplete of recoverable crude oil, which is just the opposite of a pressure solution type reservoir, which is produced exactly the opposite way and does create a large pressure differential to the adjacent formations.
But if I understood, you said that pulling oil and water out would create a pressure differential.
Correct.
So I believe Mr. Williams testified that there are several offset operators around the Stumps leads who are pulling water and oil out of the Arbuckle. Are they not creating a pressure differential?
Yes.
So would that not affect the Stumps number 4 well?
There is so much in a mile, let's see, in 10 acres, you're at 1.4 million barrels per 10 acres. So 100 acres is 14 million barrels. They're on probably 320 away. Yes, there's a 50 million barrel pool that they're drawing from of fluids. So this goes like our debate over potentially. With 50 million barrels and no pressure differential in our well, they're not going to be drawing selectively from anything on the Stumps location. They're going to be drawing from the fluid that is most mobile around their own wellbore.
But I believe I heard you say potential. So there is a potential that they are creating a differential on the Stumps.
Just like every PA well in the state has a potential for pollution, even if it's constructed correctly. Every well drilled through the fresh water has potential for pollution. So what percentage, I mean, you know, you want to put a hard number on it or something.
All right. I think I'm done with my questions for now. Thank you.
Okay.
Thank you, Mr. Kimbrell. We'll turn to commissioners for questions, and I'll start with Commissioner King.
It just turned noon, so good afternoon, Mr. Ferris.
Good afternoon. Thank you.
A few questions
It's
for you.
always dawn on your backdrop there.
I'm sorry.
It's always dawn on your background.
Yeah, for some reason, the sunflower is spaced away from the sun. I can't figure that out either.
Yeah.
But moving on, how long have you been in the oil and gas industry?
Since I started operating or since I started working for other people?
Either way.
I worked for Slauson Oil starting in 1983.
Okay. And you've been on your own for how long?
Incorporated my company in 1986, started operating our first wells in 1991.
All right. How many leases do you currently own?
35 or something, more wells than that. Multi-well lease, maybe 40 to 45 leases total.
All in Kansas?
Yes, all the wells that we own and operate are in Kansas, correct.
Are you operating mainly in Western Kansas? The counties in Western Kansas?
Yes.
Yeah.
Yes.
Okay. Let's talk about this lease for a little bit. When was it? As I understand it here, you're stating that you haven't had sales since 2015 from the Stumps, but the last date of production was sometime during 2017. Is that correct?
Correct.
When did you last try to produce the number 2 Stumps?
I believe it was in, the number 2, not the entire Stumps lease. I believe this number 2 has been TA'd. The number 1 and the number 4 were the 2 wells we were trying to produce at that time, is my recollection. But the number 2 may have been down longer, I believe.
The point I'm getting at is number 1 and number 3 have been plugged, right?
Correct.
So I'm just want to focus on just number 2 and number 2 and number 1 have been the ones that you produced up through 2015, and 2 and number 4, I'm sorry, number 2 and number 4, 2015, and then intermittently until 17 produced, right?
I believe it was number 1 and number 4, but I'm not 100% positive. It might have been number 2 and number 4.
When was the number 1 plugged?
After
Production cessation?
No, it still kept making crude oil. And then we had some problems, and the TA on the Arbuckle has a very high fluid level. And so unlike most of the parts of the state, if you see a high fluid level, you think you've got a shallow water break-in. So we had a lot of TAs on the well with a high fluid level, and then at one point it went a little higher, and I think Bruce, or maybe Richard, I believe I've talked to Richard on the phone about this lease, said that's too high. We think something's going on out there. So we went out there and ran a packer in the hole and determined that it had a casing leak. And at that time, with the expected remaining production of the Stumps number 1 with a casing leak, it was clear that was the time to plug the well.
And roughly when was that?
2019.
Okay. It's been subsequent to 2017.
Correct. Yes.
Okay. In this latter stage, leading up to this let's take the 2014, 2015 through 2017 period. When you were trying to produce the lease, what was the average total daily lease oil production?
Depending on how many wells we're on, I believe the number 1 was capable of like 5 to 7 oil a day. And the number 4 was making like a barrel and a half, 2 barrels a day.
And what was your average daily water production? Ballpark.
The number 1 was pretty high. With that pumping unit going full out is probably 800 barrels of water a day. And the number 4 was like 140, 180 barrels of water a day.
Okay. So you had to move 800 barrels of water to retrieve 5 barrels of oil, basically,
Correct.
or 140 barrels of water to retrieve 1 barrel of oil.
Correct.
So if I turn back now to the staff exhibit number 1, which is this letter you wrote to Mr. David Wan on December 12th of 2013. And we could bring that up again if somebody has it available.
We
Tristan,
have
do you-
copies in this
I've got a copy. Thank you.
Okay, yeah. What I want to focus on is a little different here. I'm looking at the 3rd paragraph. Okay.
Okay.
It says the number 4 oil cut is about, if I'm reading that, that's 1/10 of 1%.
Correct.
And the number 2 had an oil cut of basically 1/2 of 1%.
Correct.
Right. How's that economic?
In 2013, the Arbuckle has such a high fluid level that the number 2 was economic. The number 4 remained on to satisfy the requirements of the dual completion, which was that it still produced oil and still produced water in the other things. The number 2 was still economically profitable at that time.
Okay, we can take down the screen share. Thank you. So we have no sales. That's kind of a critical point there. No sales since 2015. We're 8 years now down the trail since 2015. Do you believe that today you have a valid lease on the Stumps lease, for the Stumps property?
The original lease is no longer valid that the wells were drilled under. We have a new lease. So there was a period of time that it did not have a valid lease. So that's when we just shut everything in and started working on the process of getting a new lease, which we've done. And so we do have a valid lease and an ownership of some mineral rights currently. But
I'm sorry, I didn't interrupt, please.
sorry, but
I didn't mean to interrupt you.
Sorry, the existing original lease has certainly terminated. So I hope I'm answering what you're asking.
Yes, you are.
Okay.
So tell me about the current lease. Who's that from?
I would have to look up, we've got the name. Oh, no, I saw the.
It's here. Excuse me just a second.
Rita Hammond, I believe.
Rita Hammond. And what percentage of the mineral interest does Rita Hammond own that she's giving you a lease on?
I believe a 16th.
A 16th.
Correct.
So we still have, of the mineral interest alone, we still have 15/16 you don't have a lease on. Is that correct?
Correct.
Well, how can you claim that you have a valid lease on the Stumps property with only 1/16 of a lease in your control?
That's why we've gone to the partition, but you can actually drill a well, I believe, under Kansas statute with a single lease owner. Now you're carrying everybody else that they can come in after the well's completed, but I believe that's Kansas law, but I'm not a lawyer either.
No, I'm not here to debate Kansas law with you either. But do you actually believe that you could have an attorney based upon this 1/16 interest that you hold, actually draw up a title opinion to present to a first purchaser such as CHS, so that they would accept that, come out and pick up whatever remnants of oil you have in the tank today. Do you actually believe that would happen?
Oh, absolutely not. No, because, and that's what my attorney advised me, Rod, this is so complicated. And you've been trying to get the leases and there is essentially zero chance. They've had trouble determining the title chain is how complicated this leasing situation is. And multi-family members have an animus about this lease that is very complicated things that they don't want to talk to each other. So yes, I'm following along with you. So on the TA application, it says check the box. Do you have a valid oil lease? Yes or no. So I checked the box yes or no, because I believe the most correct answer to that question was yes. Would I get a drilling rig headed there, owning 1/16 of the middle? Absolutely no. So I hope that answered the question. So yes,
It does. This is I'm sorry, please.
Go ahead. I keep interrupting you.
This is a giant Paul Harvey moment. The rest of the story is 15/16.
Correct.
That's a big what if, is it not?
Yes. But when it goes to partition, it will get settled to somebody. They've started the legal process. My understanding as a geologist is, the decision to fish or cut bait has now been forced by the partition action. So the one guy that's trying to obstruct everything, if he decides he wants the minerals, somebody's going to come out with this with 100% of the minerals, which greatly simplifies the entire path forward.
With respect to this subject well, the number 4 well, when it was used as an injector, did it take the injection fluids on a vacuum?
Yes, it did.
You never had to pump it. It was always on a vacuum.
No, yeah, always on a vacuum.
Okay. With respect to that gamma ray neutron law, we don't need to call it up. You're a professional geologist. I just simply have to ask you, the markings in the center along the porosity side, the hash marks, does that indicate open hole, or what does it indicate?
No. So a lot of the logging companies, and of course, due to copyright, they have to call it different things. But in that era, that was like a quick look porosity marker. So, which, is very helpful in.
Okay, I got it.
So it's, as you guys went higher up on the log, you see the lancing zones that had porosity. Every single porosity break in the lancing had, 3 or 4 feet of tick on the log. So that's what they were marking on that log.
Okay, so is it safe to conclude that all the marks, whatever, on the right-hand side of the log are basically porosity markers, and that none of them are indications of perforations?
Correct.
Okay.
And
Okay.
they're machine drawn, not hand drawn.
Okay.
They come on the original log when you're on location and the logging engineer brings it to you. Those hachures are on the logs then.
Okay, very good. Let's go back to these MITs, because I think it's something I heard Richard Williams say, and I think it's something I heard you repeat, and I want to make sure I'm clear about what it was that you said. Let's take the last, as I understood it, the last 2 MITs that were conducted on the well. One was conducted with fluid in the hole in the annular space. Is that right? Is that correct?
Yes.
Which date was that?
Well, when you said one of them, I don't know how to answer that yes or no, because all of them were. I mean, now we're doing MITs in the traditional manner, which is why I moved the well to this configuration such that every single MIT that's been performed since the wellbore configuration has been changed has been performed with fluid in the hole, in the annulus between the tubing and the 7-inch production casing. Yes.
to the surface.
Correct.
Okay. Somehow I thought I caught in there that one was conducted without that and one was conducted with it. So I must have misunderstood what you said.
The very old ones, when I wrote the letter to Mr. Wan in 2013,
Right.
those tests weren't conducted with fluid pressuring up the casing. Matter of fact, the casing was never pressured up. Correct.
Wow. All I can say is wow.
Yeah.
Let me have you explain why I said wow. If you do a pressure test with fluids, with liquids, you're likely to get a different test than if you do it with air or gas, are you not?
Through permeable medium, yes.
I mean, on an MIT, not through the zone, on an isolated MIT area.
If you pressure it up with gas and it temperature stabilizes and everything, it should go to 300 pounds and hold there. There'll be gradual heating of the gas, which we see overnight when we leave things shut in and everything. But if it's more like, you can't be a little bit pregnant. Either it's sealed or it's not sealed. So on a gas test versus a fluid test, it's either one or the other.
I guess let me ask the question differently.
Okay.
I'm looking for something very simple and very basic law of physics, actually. Why is it the state today, in your opinion, requires that the annular space be filled with corrosion inhibiting fluid prior to an MIT? Why is that?
To reduce the corrosion in the space on both the casing and the injection string.
Why wouldn't you just have air in the space? Why have a fluid? Why have a liquid?
You can't evacuate the bottom of the well effectively. You're right. I mean, it would be even safer to run it with air, but you would have to construct a valve at the bottom of the well, and even with swabbing, you can't get 100% of the fluid out. So
now, I'm not trying to be anywhere near that complicated. I think it's much more simplistic than that. Much more simplistic.
okay.
Doesn't it have something to do with the fact that gases and gas and liquids are both fluids? So I'm going to try not to use the word fluid.
Okay.
That liquids are non-compressible. Gases are compressible.
Correct.
So if you get a 300-pound reading at the surface on something filled with gas, that may not be 300 pounds at all if you were using something filled with a non-compressible liquid. That way you get a true test. It has to do with the true and the merits of the test, does it not? Isn't that what they're getting at?
No.
No.
I mean, we test pressure vessels with gas all the time, and they're valid tests. So incompressible versus compressible, yes, we're compressing gas at the surface and could get it up to 300 pounds. And if it holds at 300 pounds, then there's no leak in the perforation.
The perforation's isolated. You won't have the perforation.
Or a casing leak or a hole in the tubing. I keep answering the question as I understand it, and I'm clearly not answering what you're asking. So,
well, we're trying to determine whether the casing has true mechanical integrity.
okay.
So we set a statewide. We basically set, for most wells, we're going to set a standard of 300 pounds. If it exceeded 300 pounds for the time that the test is required to be run, it passes the test. But the other condition is that the annular space be filled with corrosion inhibiting fluid. That's unless it's, I'm not talking about fluid depression tests. I'm talking about casing MIT tests. That's the way it has to be. The two work together. You got to have the pressure together with the non-compressible liquids. Otherwise, the amount of the pressure that is able to pass the test is irrelevant if you're using gases. Isn't that true?
Sorry, I was reading.
I promise I will not ask this question again.
Yes, passing it with the gas when the state doesn't allow it to pass for a gas doesn't have you meet the state requirement, but literally you could test mechanical integrity with the gas.
Okay. I have no further questions. Thank you.
Okay.
Thank you, Commissioner Keen. Turning to Commissioner French, questions of the witness.
No questions. Thank you.
Thank you. Good afternoon, Mr. Ferries. I just, you referenced studies that you've done to determine the economic aspect of proceeding. What studies were these and who did them?
I'm not positive what you're referring to. But I think the economic studies I was referring to would be changing the water migration pathways in the top of the Arbuckle. Would be one thing. And just while I've got everybody on, the one thing in my testimony is I might as well just state it just clearly for you guys. Our intention before this all got caught up and my attorney was Chuck Wooden and then he couldn't progress and then I had attorneys at Folsom Siefkin and they weren't oil and gas guys, so I eventually got it over to Chris, who understood all the problems on here. But the whole time I've just been trying to safely TA the Stumps #4 well with the Packer in place and a good MIT showing that we're not doing. And then we would like to drill a new Arbuckle well showing on the seismic potential locations that we have. And, you know, a good well would be 45 barrels a day and 200 barrels of water. And that's more than you can dispose of by truck treating. Well, when it's 45 barrels a day, you could buy a truck and hire a 21-year-old to drive all day long, but mostly that would be economic. And then test the Stumps #4, get everything done, send the EOR application to the KCC for approval, and then proceed from there is what I've been trying to do very, very unsuccessfully for a long time. So that would be, so drilling the first well and then having to drill a second disposal well greatly changes. Basically, you have to make enough money on the first well to pay to drill a second well. So that
Right, and that is my point is
Okay.
you, when I believe Commissioner Keen asked you this question, if I'm not mistaken, you responded, yes, you had done studies on this because the concern is the economic viability. $300,000 is the cost to drill and complete a new saltwater disposal well. And I'm reading from page 5, line 16 and 17 of your testimony. And I think then also discussion about saving $30,000, but ultimately it was, I think, maybe if I'm wrong, but I thought you had shared that you have done studies to ensure the economic vitality of your proposed plan. So that's what I'm asking.
I'm not getting.
Is this? Are you saying you're doing this based on your knowledge as an operator and?
Yes, and drilling a new well is always, no matter how good the seismic looks or how good the well, 30 acres away that you're offsetting, how good it is no guarantee. There's no study we can do to prove you're going to drill a successful oil well on the next one we're just, the earth is far too complicated for that. So no, I can't prove, hey, if the commission does this, I guarantee I will bring in more jobs and more tax dollars because we're going to for sure drill a new well. No, I don't have a study proving that. That's based on my own experience and what the 3D seismic showed for us. Is that closer to what you're
Yes,
asking?
yeah, thank you.
Okay.
I was just, if there was, I wanted to know who had
Okay.
done it and when it was done. Okay, thank you. Let me look here. I have to admit, Commissioner Keen, some of the discussion you had with the operator was a little bit beyond me. So, but interesting nonetheless. You also mentioned, I believe, in just your discussion, Mr. Ferries, that you had conversations with Mr. Williams. Is that correct?
To my recollection, yes. There's a lot of stuff you do with the KCC that's just straightforward, and I know what to do, and I file the paperwork. And then I have things that have curveballs, and usually I call, District 1 or District 4 and just say, hey, this well's a little bit different. What do you need me to do? And the guy says, here's what I need you to do. Make sure you do this on the paperwork. So they're very short conversations just to get some guidance that I'm sending in the right thing that they want to see is most of it. And then Bruce Rohde comes out when we MIT the wells or squeeze it or everything, and we talk about pheasant hunting or whatever while we're doing that on location. So those are my longer conversations with KCC staff.
Okay. All right. And you agree that you and staff had an agreement that you would perform an MIT on the subject well. This was on or about September 14th, 2018, right?
Yes. I actually, do you want to ask more questions or do you want me to expand on that answer?
No, that's fine. And then you received further documentation about production tubing.
I don't know what you're referring to on the production.
That you were sent a notice of violation stating that the subject well did not meet the production tubing requirements and provided a 6-month deadline to March 14th of 2019.
Okay. I don't think it says production tubing, but yes. So on the notice that I got, and that is where I didn't understand the ramifications. We would pass the MIT, which me thinking as a geologist and an engineer is the important thing to do is make sure we're, like Mr. Keen said, the most important thing is old well, old casing, make sure you pressure up to 300 pounds and it holds solid. So then they would add the footnote that we will take away your disposal authority because the well is not doing that. And I'm like, well, that's fine because I need to get all the minerals back together on this lease and get, like Mr. Keen said, get the drilling title opinion from the attorneys and everything. And at that point, when I get the hard thing done, then I would just apply to the commission for a new EOR disposal authority under a new docket. So the problem is when they were sending me that note, I didn't realize Mr. Kimbrell had me read that section of the specific things after the well goes. And I thought incorrectly that if I passed the MIT and just let the disposal authority lapse, and I always told them, hey, absolutely, we're not disposing any water in here when we don't have authority on it. That I was making a good faith compliance effort, trying to get the big thing done first, before I did the small thing, and having the well buttoned up was the safest thing to protect fresh water, and be able to perform valid mechanical integrity tests. But Mr. Kimball brought that up, and I did not realize the ramifications of doing that. I even sent the disposal paperwork, like they said, to Mr. Noble, maybe, I can't remember the name. And he said you needed more. And I believe I said, I can't even track down the correct parties for notice. We need to do a, oh, Diana did a, not a record check. What's the legal thing? Title opinion had to be done before I could even provide notice to the proper parties on who owned the minerals to give them notification under the KCC rules for applying for the disposal application.
Okay. That's all I have, Mr. Ferries. So let's turn back to, I'm sorry, Mr. Steinkamp, for any redirect.
Thank you. Hopefully I can ask a couple of questions that may clear up some of the confusion on some of this. There's been kind of two periods of time, let's say, with this well, correct? One of those time periods would be prior to 2018, when the well was reconfigured by agreement with Mr. Stuckey, right?
Correct.
And during that time period, the well was dual completed, correct?
Yes, until we reconfigured it, it was dual completed.
Correct. Okay. Can you do a pressure MIT test on a dual completed well?
No, it was impossible. Under the permitted configuration, I couldn't prove that the casing was still good.
Okay. And the commission regulations allow you to conduct an alternate type of mechanical integrity test in those circumstances, don't they?
Correct. Yes.
Okay. And your letter that we've talked about from 2013 is what the agreement was between you and the commission under these alternate testing protocols as to how you were going to determine that the well had mechanical integrity. Am I right?
Correct.
Okay. And so then moving to 2018, what the agreement was with Mr. Stuckey was that we're going to not have this well continue to be dually completed, and you're going to set a packer above the Arbuckle, right?
Correct.
And then you're going to pressure test the long string and the surface casing and all of that with fluid thereafter, right?
Not the surface casing, the production casing.
The production casing.
Correct. But
Okay.
yes.
So that you can establish with a fluid pressure test like a traditional well
Correct.
that the well holds casing pressure.
Correct.
Okay. And that's what you've done 3 times since 2018.
Yes.
And it's held pressure every time.
Correct.
Okay. And let me ask you this, just to be clear, prior to 2018, it always passed the substitute mechanical integrity test, right?
Well, yes, a little bit prior to that, that the oil production was declining in the Stumps number 4, and it's a low well. So, you know, at some point, the proof is you don't have a casing leak if you're still making oil production, which is not a perfect proof, but it's an acceptable proof to the KCC under their other requirements. So, you know, as Mr. Keene pointed out, you know, that well was not economic, but having that well operate that way was economic for the overall lease, which is what he pointed out in his questioning, which is 100% correct. That's how we were doing it. So at some point, the Stumps number 4 just declined too far to keep it going.
Okay. But you were evaluating the economics, not on the Stumps well in isolation, but the lease as a whole was continuing to make money at that point.
Correct. Yes.
Okay. And just to ask a couple of questions again on Commissioner Duffy had asked you some questions concerning the studies that you were referring to, and those studies were other academic type of analysis of the Arbuckle that demonstrated that you can use EOR in the top of the Arbuckle successfully, correct?
They're usually an academic with a couple oil companies that they used as guinea pigs and tests, or the service company that does it, that does the gel treatments or something, works with 4 or 5 oil companies, so they have case studies in the area, and then usually an academic who wants to publish, and that's how it gets in the literature for other companies to find out about a successful or an unsuccessful process.
Okay, and so those were the kinds of studies you were referring to.
Yes.
Okay. And that's kind of the idea that you have on this EOR thing with this particular well, right?
Correct.
Okay. So the point of this matter as a general proposition is that this well has substantial value in the operation of this lease. It's not about saving 3,000 feet of casing or something like that.
No.
It's about,
Well, the partition's going to cost more than that to do the legal fees and acquire it. So, yes, I mean, Mr. Williams talked about stalling, and I've seen guys that stall on leases and stuff. No, we're trying to move forward with the next step on this lease, and it's costing more money than delaying plugging the well is saving. If that, hard to see when I haven't followed through on things that I said I was trying to do, but yes, that it's very clear we would not have made the decisions we made to stall plugging a well that we're going to have to eventually stall. There has to be a perceived value to us for our actions is why we're doing what we're doing, if that makes sense.
yeah. What does it cost to plug one of these wells?
Depends on what the state says and how easy in cement prices. I don't know, 12,000 on an Arbuckle maybe.
Okay, so you're spending a lot more money to not plug the well than if you just went
Then
and
we would
plugged
have
the
plugged
well.
it. Correct.
So this isn't about saving the plugging costs.
Correct.
This is about saving the resources in this.
Correct. Saving that disposal well has great value if we can get a good producing well going on the lease again.
I don't think I have any further questions.
Very good. I will turn to Mr. Kimbrough for any recross.
Thank you. Just to bring up the agreement with Renee Stuckey one more time. So the agreement was that in 6 months you would plug, produce, or reconstruct the Stumps number 4 well. Is that correct?
Agreement is, we were trying to get an MIT on the time, and I think we called from the field, and Renee said, hey, go ahead and change it and let's do a real MIT. And we did that, and that's my recollection of how we started, Mr. Kimbrell. Then I thought my failure to get the disposal agreement going, they'd say, and that's going to cause your disposal authority to lapse. And I'm like, fine. I didn't realize that the disposal authority lapsing set a timer on the well. I thought disposal authority lapsing meant I couldn't inject or dispose of any fluid in the well, which was a fine outcome for me to have that outcome. So, in hearing everything today, that was a misapprehension, a misinterpretation of the rules on my part, Mr. Kimbrell.
Okay. So if I'm understanding you, you're kind of saying that you made a decision that's kind of ignoring the agreement with Renee Stuckey made more sense.
Well,
Right.
I didn't ignore it. I thought the ramification was that we couldn't dispose of salt water, and I did the new disposal authority and talked to Mr. So I did follow through on the agreement on the first step, not all the way to consummation. And then when it came back and he said, and I even think I might have even just set it in for what's it called short of the agreement, design, sent it in for design approval, just if we would be able to inject it there. And I think he set back that you're going to need to notify all these guys. And that's when I talked to Chuck Wooden about the title, and I brought him, so when I was out plugging the well, I went and did record checks in the courthouse and started pulling all the title stuff, and CHS had title, and they had complications in their files and a whole bunch of suspended owners that they couldn't find either. So correct, that is when I did not finish the final step of what he had recommended.
Yeah. And you said that you started looking into title in 2018. Is that what I'm
I believe
understanding?
so, yes.
Okay. And when did you finally get attorneys who started doing the actual title search?
Mr. Wooden, pre-COVID, working with him, he reviewed my documents and said, these are the guys I needed to start contacting. And I did contact several of them. And that's when I talked to Mr. Cryer and some of the other people. And that's when Mr. Cryer said to me, oh no, I've got all the minerals out there. You can't lease anything. And I said, well, no, you don't have the minerals. And he said, well, yeah, I do. They're coming to me in a few years. So I'm just going to hold off on everything out there. And I came back and told that, and Mr. Wooden said, no, that's not right. When he has term limited minerals, he can't block the development of the acreage for the current owners at the time. And then Mr. Wooden retired, and I tried some other attorneys there and finally brought it to, I don't know, Mr. Steinkamp. I'm sure he has a first date of agreement for us a year ago. I don't.
Yeah, approximately that.
So something in that ballpark.
So 2022. So from 2018 to 2022, there was no real work done on the title search.
There was a lot of work done. A lot of work done. There was very little progress actually made. Very little progress.
All right. I have no further questions. Thank you.
All right. Thank you, Mr. Campbell.
Okay. Thank you. Real quickly, let me just ask you, Mr. Steinkamp or Mr. Ferries, you said you have not been on the lease in years. Is that correct?
I went through, they were cutting the pipeline right away, and my old pumper lives near there, and he said, Rod, you should go out and talk to the foreman there. And I was up in Ness County or something, so I did go there, but I didn't have a tank gauge. I didn't gauge the tanks or do anything like that. So I've been on location. Someone did run a pipeline across the lease a few years back.
Okay.
And I just met with the foreman out there just to tell them where our wells were and where our flow line was.
Okay, and that tank is sitting out there with some amount of oil in it. You're not quite sure how much, but some production is sitting there. So does a pump man or landman or roustabout or anybody you employ ever go by there?
No,
No.
we don't. I assume it sat there long enough that it went to the reclaimer. So because CHS would let us sell partial loads of oil. So I cannot state with certitude that we have a partial load of oil there, because I'm 98% sure I would have sold it. So, but there may be a little tank bottom in there, 5 inches of BS.
All right. Thank you. Thank you, Ms. Ferries. I believe that concludes the questioning of the witness, and you may virtually step down. Wait, Commissioner Keen? Are
Yeah,
you waving at me, or?
I'm not trying to be the skunk of the picnic here, but I just have some very brief follow-up questions.
Oh, I'm sorry. I didn't realize that. Go ahead, please.
Mr. Perry, does the tank battery have secondary containment?
It has a dike that's looking pretty dicey, I would say at this point, would be my guess.
Are the stock tanks and the gun barrel, they steel or fiberglass?
I believe the gun barrel might be redwood from 6.
Wow,
Redwood.
that's
If not,
an antique. Yeah.
if not, it's fiberglass and steel. Our other lease that we used to operate in Barton County had redwood from about that same time frame. So it may be redwood and steel.
Redwood and steel. Would you take a guess at the vintage of that redwood?
Oh, I'm sure it was cut in California in 1962 or 1963 or something.
Barely post-war. Okay, let me move on here. Why did you acquire a fractional interest in the mineral estate? What was the purpose for that?
I believe, following my attorney, the partition suit must be undertaken by someone with a direct mineral interest. He can clarify if that's not correct.
Okay, I understand.
That has to be who initiates, I believe.
Okay. Before the lease was shut in, you have any idea of roughly what was how are these wells produced? Are they produced with electricity or natural gas, propane? You do
No, electric line on 160 or 114 pumping units. Yeah.
Okay. And so roughly, before the lease was shut in, do you know just roughly what was your monthly electric bill?
It depends how many we're running. They had such a high fluid level. It wasn't that bad. It was like Midwest Energy, 300 to 600 a month, something in that ballpark.
Okay. Final question. Was it necessary for you to use corrosion inhibitor to protect the tubing in your wells on this lease?
Let's see, Mick can treated those. Yes. Yes,
Okay.
we could use corrosion inhibitor.
Okay, thank you. And no further questions. Thank you.
Thank you, Commissioner Keen. I believe now, Mr. Ferris, you may virtually step down.
Thank you, everyone.
We will now move to closing statements and we'll begin with Mr. Steinkamp.
Thank you, Commissioner. May it please the commission. We've heard a lot of testimony about this well, which is obviously a complicated well, and it's had a long history. It's a 60-year-old well at this point. I think Commissioner Keen calculated it to be 59 years old or thereabouts. This well, as we've heard, was originally a dual completed well with two separate completions in the Arbuckle. And I think the testimony has been that when that happens, a traditional mechanical integrity test is not possible. And we have a letter from Mr. Ferris that's been in evidence that explains an alternate method for mechanical integrity to be demonstrated. And those types of alternate methods are set out in KAR 3-407 sub, looks like sub A4. There are multiple alternate methodologies. And one of those methodologies is that you show that you have production from the zone that shows that it hasn't watered out. So therefore you are demonstrating that you don't have a casing leak. That was what was being done. And Mr. Ferris talked about the fact that they also used dye to demonstrate that they didn't have a leak in the packer or a leak in the injection string. And so you've heard that evidence. In 2018, the well was reconfigured by an agreement with Renee Stuckey, who was then the UIC director. He was the predecessor to the current MIT director, Mr. Bryant. And what they did was they just set a packer on top of the Arbuckle and then pressured up on all of the shallow zones as you would in a normal disposal well to demonstrate that the well held pressure. And it demonstrated that fact 3 separate times, once in 2018, once in 2019, and once in 2022. And what's important about that is that those tests all demonstrate that this well is sound. It may have used casing that was installed in 1964, but it holds pressure, and it's continued to hold pressure. And what the KCC did in response to this reconfigured well was it was initially passed because it was under the agreement with Renee Stuckey. After a period of time, they decided that, okay, well, that only is valid for a certain period of time. And so we'll have to retest. The retest was subject to looking at all of the permits being proper. It wasn't a question of whether or not the well was safe as a physical matter in the environment. It was a matter of, was the paperwork correct at the Kansas Corporation Commission? And the KCC determined that the paperwork did not match what was physically done in the well. And I think that's a very important distinction. The environment is not harmed by incorrect paperwork in the KCC's office. The environment is harmed by a well that leaks into fresh and usable water. And in this instance, we have 3 separate demonstrations that this well is not doing that. So that I think that's very, very important. The other testimony that we've heard today is that this type of well could create waste, and the theory advanced is that the lower Arbuckle zone could flow up the hole into the upper Arbuckle zone and cause waste by diluting the amount of oil that's present or something to that effect. And we looked at the log on this, and the log shows that the Arbuckle has uniform permeability and porosity from the top of the Arbuckle down to the bottom of this well, essentially. And that demonstrates that all of the Arbuckle is in pressure communication with itself. So there's not a differential between the lower part of the Arbuckle and the upper part of the Arbuckle that would cause water to flow from one area to the other. Staff's testimony was very careful to state multiple times that this well is a potential threat to usable water and has the potential to cause waste. Potential is a big word. Potential for pollution of fresh water happens every single time you drill a well into a freshwater zone. I don't care if that's a water well, an oil well, or whatever it might be. There is a potential. The issue here, though, is, and stated carefully by staff as well, that when you have a well constructed properly, that potential is strongly mitigated. And in fact, in this instance, it is shown to be eliminated because this well holds pressure. So there is in fact no threat from this well because it was constructed in compliance with the KCC's regulations at the time, and it is continuing to perform as designed right now. Is the paperwork the ideal thing? Clearly not. The next thing that we've learned here today is that part of the agreement with Mr. Stuckey and Mr. Ferries was that after we tested the well in a traditional MIT pressure testing manner, that Mr. Ferries would submit new paperwork, and he did that. And one of the issues that arose when he did that was, well, when you do these kinds of reconfigurations, you've got to give everybody that owns an interest in this well notice of what you're doing. Well, when that happened, that's when the issues with the fractured title became very obvious. And the ability to give all those people notice, it just frankly wasn't possible. And I would direct you to the title memorandum prepared by our office showing how fractured this title is. And as Mr. Ferries testified, he discovered that those fractured owners harbored a fair amount of animosity for each other and didn't agree on much. The owners include even the state of Kansas, which has opined to us that they are legally not entitled to own title to property like this. Nonetheless, they were granted that title by a probate court. So what to do in that circumstance, I don't know, other than to file a partition action, which has now been filed. Clearly, all of this has taken a lot longer than the commission would like, and the commission and commission staff, I think, has been very cooperative with Mr. Ferries and has tried to give him time to get things done. And I think, unbeknownst to that staff, he has been in fact trying to get those things done. These problems are difficult and they take time, as he testified, I think, and I really honestly wasn't aware of all these things, but I did know that Chuck Wooden had represented him. Mr. Wooden is in his 90s, I believe now, and is finally retired. I think that that was kind of a factor in what was going on here. And in any event, at some point, not terribly long ago, he ended up in our office, and we've been trying to help him get this sorted out. So my final point really is this, that the KCC has been very patient. We understand that, and we frankly appreciate that. I mean, the staff, I think, makes an effort to allow oil and gas producers to fix problems, and they try to help them come up with suggestions to fix those problems, and that's clearly happened here. Where the staff falls down is that they're not lawyers, as they all admitted. And the legal problems in this circumstance have created a major ball of trouble that has prevented things moving faster than anybody would have wanted it to, certainly Mr. Ferries as well. So the point is, staff has identified and very carefully stated that this well creates a potential threat to correlative rights. It creates a potential threat to safe water. Our position is that we have demonstrated, whether fully accepted by staff or not, that this well does not create a threat to safe water, to drinking water. And we've also demonstrated that it does not, in fact, create a threat to correlative rights. Staff testified there's been no complaints or any evidence establishing either pollution or violations of correlative rights. Not that that is a requirement, but nonetheless, there's no one showing or arguing that they've been hurt by this well. And there is no evidence out there that says that there's any reason why they would complain. So what we're asking, we're in the middle of spending a fairly large chunk of money to try to fix the title so that this well can be fixed. Then once we know who owns it, which hopefully will be Mr. Ferries, it will be easy for him to give notice to the mineral owners as required in applying for a new injection permit or a new EOR permit or whatever other kinds of things he may do. EOR seems to be the most likely direction he wants to go with this, which will result in presumably the recovery of additional oil and gas reserves. So what we're suggesting is, rather than causing actual waste by the plugging of a well, which we've done, is a $300,000 circumstance, let's not create actual waste to protect against potential waste as testified to by the staff. And we would ask that if the commission is inclined to enter an order requiring action be taken, that we could receive a conditional order giving us the opportunity to continue this partition, get the title fixed, and then file all of the appropriate paperwork and bring this well into compliance with the commission's rules and regulations. Thank you.
Thank you, Mr. Steinkamp, and turning to Mr. Kimbrell for your closing statement, please.
Thank you. Commissioners, the testimony today has shown that Great Plains has had a very long time and a lot of opportunities to bring the Stumps number 4 well into compliance. And Great Plains is not taking advantage of those opportunities. At some point, Great Plains shouldn't be given any more time or any more opportunities to do what it should have done a long time ago. Mr. Steinkamp has just argued that the Stumps number 4 well is properly constructed, but it's not properly constructed. That's part of the reason that staff has issues with this well. The surface casing needs to be lowered in order to protect fresh water, and the MITs that have been performed have been above the production perforations. We have no idea what's going on below the production perforations in this well because they haven't been tested. They can't be tested. We've talked a lot about the word potential today. Commission regulations exist to deal with potential issues before they become actual issues. So given that the Stumps number 4 well has been out of compliance for so many years and that continues to be a potential threat to freshen water and correlative rights, staff requests that you order Great Plains to plug the Stumps number 4 well. If you decide not to order Great Plains to plug the well, then staff requests that you at least order Great Plains to take actions to bring the well into compliance with commission regulations, and chiefly sealing the production perforations, making sure that the surface casing is adequate, and filing a new injection permit. Thank you.
Thank you, Mr. Kimbrell. Before we conclude today's proceedings, I want to see if there are any post-hearing issues and whether the parties would like to file post-hearing briefs. And Mr. Steinkamp, if you would like to weigh in first on this.
Thank you. Yes, I think there's a number of legal issues here as well as some complications that may bear on what's going on with the paperwork at the KCC's office, the partition, the regulations. I think it would be useful to file such a brief. So we would like the opportunity to do so.
Mr. Kimbrell. do you
Yes,
have-
staff would not be opposed to filing briefs as well.
Okay. And I'm fine with this as long as we're specific and not rambling in our post-hearing brief. And further, what about 10 days? Would that be suitable for everyone in meeting that deadline?
That is what is that? September 10th, I think? or
Yeah.
11th? I don't know what day. I don't have my calendar up.
John, can you help me here? How?
It would be Sunday, the 10th, so
It'd
it
be
would
the
be Monday,
11th.
the 11th.
It'd be the 11th.
That would be fine for staff.
Staff says it's okay. What about you, Mr. Steinkamp? I'm sure you're on board as well.
That's fine. Thank you.
All right, very good. Commissioners, as I look around, do you have any other issues you'd like to raise? And Commissioner Keen, I'll begin with you. No? Yes?
No, thank you.
Okay. All right, very good. Commissioner French. Very good. This concludes our hearing in this docket. At this time, we will close the record and adjourn. Thank you all for your participation and have a good afternoon. Thank you,
Thank you
everyone.
all for your time. Thank you.
Thank you, IT staff. We appreciate your diligence.
Thank you.